By That matter which was reserved for judgment, my lord,
Correct.
that assessment order passed on the dead person.
Correct.
One factual aspect I had failed to bring to my lordship's notice. May I request that the matter be
ಎಲ್ಲ
listened?
ಹೇಳಿ ಮತ್ತೆ ಮತ್ತೆ ಹೇಳಿದ್ರಿ ಇಷ್ಟ
ಅಂದ್ರೆ-
ನೆನಪು ಮಾಡಿ
My
ಬರ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
lord, two things, my lord. One is that the order of assessment, in the first line, it reads that this order of assessment is passed on the legal heir so and so. Even though on the, my lord, the name of, in the preamble, my lord, dead person
But
is
don't address it to dead person.
the
ಇದೆ.
ಮಾಡಿದ್ದಾರೆ, but still I had failed to bring it to my lordship's notice that order of assessment, the first line.
All right, you have said next point.
Next point is, my lord, one judgment of this honorable court, my lord, straight on that point, which my lord refers to 159(3), wherein, my lord, the moment of death, legal heirs will automatically be liable for the assessment anta. That I had failed to put. And then written
please.
submission ಜೊತೆನೂ ಕೊಡ್ತೀನಿ. Whatever my
Written
lordship.
submission ಅವ್ರಿಗೆ ಶೇರ್ ಮಾಡಿ ಕೊಡಿ.
Please.
ಅವರು ಇಲ್ಲೇ ಇದಾರಲ್ಲ.
Yes.
That's good thing. Which how that's going to alter your position? What is that?
ಅಲ್ಲ,
It's
ಇದ್ರಲ್ಲಿ
going to
ಏನಾಗಿದೆ
add.
ಅಂದ್ರೆ, no, legal, the order
ಆಯ್ತು
of
ಬರ್ಕೊಡಿ ಬರ್ಕೊಡಿ.
ಹಾ.
ಓಕೆ.
I'll file it along with my submission.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಕೊಡಿ.
Yes, please.
ಇಬ್ರು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡಿ.
We'll exchange ಮಾಡಿ.
ಓಕೆ.
My lords, yesterday 2 connected matters were listed. Consumer arrest warrant has been issued against the petitioner. So this one matter was not listed. So it may be listed tomorrow only because there is a warrant in force.
ನಾಳೆ ಇಲ್ಲ ಸಿಟ್ಟಿಂಗ್. ಒನ್ ಡೇ.
My lord, serial number 36, my lord.
36.
It's 2 weeks time.
ಯಾವ ಇಯರ್ದು ಅಂತ ಹೇಳ್ಬೇಕು.
Twenty-one.
We are in the matter.
Connected.
ದೇಶ್ ಅವರ ಯಾರ ಆಕಾಶ್ ಶೆಟ್ಟಿ ಅಪಿಯರ್ ಆಗ್ತಾರ.
Please, my lord.
ಅಲ್ಲಿ ನೋಡಮ್ಮ. ದೇಶಪಾಂಡೆ's name to be deleted.
Lordship, serial number 40, your lordship. I'm for the respondent.
One second.
Lordship.
Yes, sir. After 2 weeks.
Please.
ಕೊಡ್ಬೋದಾ?
Here for the respondent.
Call after 2 weeks.
Objection.
Your lordship, serial number 28. The connected matter, sir. After next week post ಆಗಿದೆ.
ಹಾ. Serial number 28.
Yes, you.
ಅದ್ರ ಜೊತೆ ಕರೆಯೋದಾ?
Yes, you.
ನೋಡಮ್ಮ. 28. Call along with.
Lordship, serial number 32.
Serial number 37 and 39, my lord.
37.
Senior counsel Shankar is appearing, my lord. Some unfortunate medical emergency.
Because of demise.
No medical emergency, my lord. Some is standing.
Good.
2 weeks, my lord.
2 weeks. On the medical ground of arguing counsel.
37, 38 and
The
30.
appellant. 37, 38.
39 also.
Muru.
Yes, my lord. He's appearing in all 3 matters.
All right.
My lord.
Serial number 40, your lordship. Next matter, serial number 40.
Ah.
I'm for the respondent, your lordship. I pray for 2 weeks time, your lordship.
2017 matter.
Yes, your lordship. Some personal inconvenience of my senior, Mr. S. Parthasarathy, your lordship.
Ah.
Your lordship,
weeks.
serial
Fine.
number
Request of
31.
Much obliged.
Counsel for respondent.
Your lordship, serial number 31. 2 weeks time may be granted. My senior is appearing in Dharwad bench.
3-1. All right. 2 weeks.
My lord, serial number 49.
Stop. ಅಲ್ಲ on request of ಬರ್ಕೋಬೇಕಾ? ಎಲ್ಲ
Serial number 49, my lord. 2023
49.
matter. Trace a week's time. my lord.
Your Lordship, serial number 32, Lordship.
2 weeks at the request of. Okay. 32.
Please, Your Lordship. A week time may be permitted, Manusha, due to the personal inconvenience of the arguing counsel, Lordship.
All right. 2 weeks. Yes. ಆಯ್ತಾ? 1 to 8, 1 week. Failing which appeal would stand dismissed.
My lord, serial number 1, I take notice, man.
Huh?
Serial number 1, I take notice. I'll file wakalat, man.
You take notice for?
Serial number 1, my lord.
Shri. So and so appears for respondent.
My lord, 2 needful done, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ 2
2, 4 and 6.
All right, now we are giving one week time. ಮಾಡ್ಲಾರ dismiss ಆಗ್ತದೆ ಅಷ್ಟೇ. All right. Next.
My lord, it is in hand summons ಒಂದು.
ಅಲ್ಲಿ registry to issue hand summons wherever appellant seeks. Okay. ಅಲ್ಲೇ ಇಫ್ ಅಪಲೆಂಟ್ ಸೀಕ್ಸ್ ಅಂತ ಮಾಡ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಪ್ರತಿಯೊಂದು ಕೇಸ್ ಬೇಕು ಅದಕ್ಕೆ. ಓಕೆ.
I'm for the appellant, your lordship.
ಹಾ.
IAF stay has already been disposed of, your lordship, by the previous order.
ಹಾ.
But it's coming up saying that IAF stay, IA number 1 is still pending. It is already disposed, the stay is granted.
Counsel for the appellant submits. The subject application in IA number 1 of 2022 has already been disposed of.
Yes.
First off, the same is noted. Okay.
9.1, I appear for the appellants. I'll
Nine-
do the
9.1.
needful within a week's time.
9.1 ಅಲ್ಲ?
ಹೌದು.
ಹೌದು.
9.2 also identical matter.
First time. You have not paid the process at all.
No, I paid, my lords, it was 2017-22, it was admitted.
Record. Learned AGA is requested to accept notice for respondent. 9.1 ನಲ್ಲಿ. Yes. ಅಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ AGA ಅವ್ರಿಗೆ ಹೇಳಿ ಕಾಪಿ ಕೊಡ್ಲಿ. ಕಾಪಿ ಕೊಡ್ಬೇಕು. Appellant to furnish copy of the petition along with all the documents on the learned AGA and file acknowledgement in the registry within 1 week, failing which appeal stands rejected.
10 and 11, Your Lordship, I pray for
10.
some time for compliance.
10, 11 na?
Yes, sir.
2 weeks.
Please.
2 weeks ಮಾಡಿ. 4 times ಬಂದಿದೆ.
Allah, fourth before the court, Your Lordship. If it had come before.
That makes no sense.
I will assure that it's complied on the.
All right. 2 weeks for
Please.
compliance, failing which
Please.
appeal petition should stand dismissed. Okay. Dismissed peremptorily. Okay.
To appear for the appellant in this matter.
Ah.
I'd like a small accommodation, my lords, next
Okay.
week.
Delay ಇದೆಯಲ್ಲ.
It's a matter pertaining to matter pending before the NCLT.
Okay.
They have been stalled from crystallizing, adjudicating.
When do you want?
Next week, my lords,
Next week.
15th or 16th.
Get the request out. Yes.
Can it be on 17th, my lord?
All right. On 17th. ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು.
Sent. Call on 17th.
Next day.
Friday ಆಗ್ತದೆ brother. Friday ಇಲ್ಲ bench. I am in 2 other benches na.
16th there.
16th. Okay. Next. Huh. Now, how that CPC, WP, writ appeal is maintainable?
It is not maintainable.
That's what.
Even authorization merits also. It's a suit for partition, my lord. In that, advocate has filed a written statement saying that
ಅದನ್ನ ನೋಡಿ. Call this matter on Monday for possible dismissal on maintainability.
and actually petition of dismiss, please, my lord.
ನಾನು ಬರ್ಬೇಕು. ಅವ್ರು ಇಲ್ದಂಗೆ dismiss ಮಾಡೋದು.
ಹೌದು, our conduct.
Okay.
That's why, Monday, my lord. Court fee has been paid.
ಅಲ್ಲೇ for dismissal ಅಂತ ಬರಿಬೇಕು. Registry to show dismissal, possible dismissal in the court list. Okay.
Your lordship, a court fee has been paid. Other objections, a week time may be granted.
Court fee is stated to have been paid. First off, 1 week for compliance of other objections finally,
Much obliged.
failing which appeal stands rejected. Appeal stands rejected.
2
Yes,
weeks, forward, sir.
2 weeks.
Well, in these minutes,
Ah.
rejoinder by the appellant to the statement of objection, not necessary, madam.
Not
It is
necessary.
only purely a question of law.
Actually, an appeal may not be an objection, but since the court permitted us to file objection, we filed objection.
ನೀವು objection ಹಾಕ್ಬೇಕಾ?
ಇಲ್ಲ, writ appeal ಅಲ್ಲಿ generally
Writ appeal.
no question of filing objection.
Objection at
That
all.
would
the
not
court
arrest, so
permitted us to
rejoinder
file.
also.
Both
Court also may not be necessary.
both the sides unanimously submit that office objection should pale into insignificance. Full stop. We agree.
But the question is about the refund, but whether the order of the learned circle judge, my lord, is in conformity with section 54 of the act or not. But there is a procedure prescribed. But the learned judge, my lord, does not refer to the legal provisions which govern the refund provisions. And my lord, a direction is now issued to the respondents to refund, not even to reconsider. My lord, page 18 operative portion, my lords.
Refund
Oh.
application is allowed. How he could do that?
But the learned single that does. Now, what has happened?
He could have
explain.
said, consider the refund application in accordance with law.
Refund application came to be rejected,
Correct.
against which I had filed a first appeal.
Correct.
There is no tribunal yet constituted. Therefore, I was constrained to approach this honorable court. So there is no, the final fact-finding authority said that my refund is not liable to be, only on purely on legal principles itself, but not on any factual grounds. They have not said that I'm not eligible because you have claimed A, actually only B is.
What was the objection?
The objection.
On what ground?
Yes.
Refund was denied.
The refund was denied on the short point that there is a procedure under the act which requires the seller. I am the recipient of certain goods, of which goods were never supplied at all. Therefore, since the contract itself was annulled, the principal amount was, I encashed a bank guarantee, so I recovered that amount. The tax amount that was collected from me by the supplier who never supplied the goods, that, my lords, that tax was collected from me and paid. So what the authority says is he should have given me a credit note. On the basis of that credit note, I should have claimed refund. But there is no denial of the fact that that refund is due to me. 2 crore 53 lakhs was collected. 2 crore 53 lakhs admittedly was paid. So therefore, my lords, the question is really under Article 265, can the state retain that amount without authority of law? Where on facts, there is no denial that that 2 crore 53 lakhs was collected from me.
What Mafatlal said about refund?
Precisely, man. Following Mafatlal, on the precise point, my lords, there's another judgment of Oswal. There, my lords, in the context of Section 11B of the Central Excise Act.
Correct.
There also, the revenue had rejected the refund on the ground that, again, this more circuitous method has to be followed. I, as a recipient, there, of course, the onus is on the manufacturer to pay Central Excise. There, the revenue said, you are not the manufacturer. You are the recipient of the goods. Therefore, the manufacturer ought to have claimed the refund and then possibly given it to you. But Section 11B was interpreted to hold that even the recipient can claim a refund. Now, my lords, my respectful submission is Section 54 is almost identically worded to Section 11B, where there is a provision under Section 54 where even the recipient can claim a refund. So any other interpretation would do violence to that provision itself, where there is a provision which allows me to claim. Of course, in the context of limitation, but identical interpretation was in Oswal. I think my instructing counsel is, I'm sorry, Malad, that judgment is, but if my learned senior friend could start, Malad, we'll get the judgment in, it's come. I'll just place on record Oswal.
But no judgment is cited by the learned single judge.
No,
Not
it doesn't
treated
appear.
matter.
No.
Ordinarily, in
Yes.
matters like this,
Correct.
there should be some jurisprudential treatment of the idea.
I agree.
Because we have to guide other authorities also.
True. Now, what the learned single judge has considered is at paragraph 6 and 7, which is at pages 16 and 17. My lords, has it? Paragraph. Give it.
Karnataka applies.
That money was paid by whom actually?
That,
By your client only?
yes, ma'am. To the supplier. So
Supplier.
I was supposed to receive goods from a supplier. Supplier collected the amount from me, but did not supply the goods. Therefore, of course, on the contract was annulled subsequently, rescinded.
The reasoning appears to be good, though
That
the
is not-
rulings have not been. Question is,
Yeah,
question is,
please.
where is the liability to pay? If there is no liability, citizens' amount cannot be retained by the king.
Correct, my lord. My lord, refund, my lord, the application for refund is not rejected on that ground, not ground.
That is rejected.
no,
Please
kindly
see
see,
paragraph 6. Where is that refund rejection order?
My lord, kindly take my lord annexure D at page 73, my lord, of the paper book. First page, my lord, the application is quoted. Then go to page 74. my
That
lord.
contract did not materialize at all.
Not at all.
The submission of the taxpayer is taken on record. Bottom minutes. However, the eligibility accounts of refund mentioned under section 54 of CGST or SGST Act is not established from the taxpayer submission.
Just quoted only section.
That is the eligibility, my lord.
He is
When an
saying-
application is submitted,
Mr. Devdas.
please, my lord.
Simple case of refund. You cannot retain money or a property of a
No, no,
citizen
that
without
is all.
authorization. Number one.
My lord, no
The con-
dispute,
Self has materialized.
no dispute about all those things.
He has made the payment.
No, no, my lord, all that, my lord, the authority is pointing out is whether your application for refund is in conformity with section 54, which stipulates that the application for refund shall be made within a period of 2 years.
But Oswald considers this.
Oswald considers this, then
Very,
my lord, no reply for this. No reply for this.
no question of law.
Then, my lord, appeal is filed. Appeal is filed. Appellate authority has considered all the submissions made for the writ petitioner. When a very elaborate order is made, but whether, my lord, the learned single judge,
Dismissed.
whether
broadly
my lord,
agreeing
only
with
one
the-
submission I am making.
Broadly agreeing with the learned single judge's reasoning. Full stop. The reasoning accords with Constitution bench judgment in Mafatlal and in Oswald. More particularly when the contract not coming into existence itself having been demonstrated undisputably. And the amount was paid by the respondent assessee himself. Next.
Grateful.
The Mafatlal judgment ತರ್ಸ್ಕೊಡಿ.
Yes, I'll give Mafatlal also.
Okay, that party ಬಹಳ big judgment
ದೊಡ್ಡ
ಅದು.
judgment ಇದೆ.
ನಿಮ್ಗೆ
Citation-
ಸ್ವಲ್ಪ ಅದೇನ್
citation-
relevant ಬರ್ತದೆ ಅಷ್ಟು pages ಕೊಡಿ.
Certainly, Malad, we'll give it. Malad, could I just make one request that refund, Malad, has been pending for about 2 years. Could a time limit be set for the
The
refund to be processed?
Refund in terms of learned single judge's order shall be made within a period of 8 weeks.
Great.
Failing which the same would carry interest at the rate of 12%. Which is that judgment.
ಅದು
That justice
interest, I think,
Dalvir Bhandari's judgment ಇದೆಯಲ್ಲ.
interest, Malad.
ಹಾ.
The act itself has 18% interest.
18%. Interest of 18%. Yes.
Grateful.
Will you also make it 12 weeks, my lord, so that we will,
Why 8? No, sir.
12
Next.
weeks.
Next.
For the appellant in this matter.
Yes.
My first office objection is regarding translation of two Kannada documents to English.
All right, translation dispensed to you.
My lord, the second is, there is a delay of 14 days. in
14
filing.
days.
I'll take a notice, my lord. We served copies in the.
Sri, so and so appears for notice. Application in IA1 of 2024 accompanied by affidavit seeks condonation of delay of a short delay of 14 days. First stop. Delay, the explanation being plausible. Delay, application is allowed and delay is condoned. Please, next.
My lord, the short point which
Ah.
arises for
No,
consideration.
no,
before-
welcome, Bharat.
ಆಯ್ತು.
Copy ಕೊಡಿ. Next. ಶಿವಕುಮಾರ್ ಏನಿದೆ?
But the copies are served on the government advocate.
ಹಾ. Ready, ready, ಕೊಡಿ. Yes.
But the
What is challenge here?
challenge is, the cognizance taken by
Yes,
land grabbers court on a private complaint filed by,
correct. But in similar matters, we have held in that judgment, in two judgments, that you should seek discharge under 9(3), read with 227 of CRPC. All contentions will go open and will not insist upon personal presence of the party also till that application is considered. All contention open ಮಾಡಿಬಿಡ್ತೇವೆ. ಮಾಡ್ಬೋದಾ? All and you will not, you are not,
the
you appear for this.
only position which I would point out to in this particular case is
Yes.
There were parallel proceedings filed by the third respondent.
ಅದು part of the record.
Yes, my lord.
ಎಲ್ಲಿ?
No. One is before the Karnataka Appellate Tribunal, questioning my legality with regard to the khata being entered into the case. But this court ordered for entering of a khata. But this court, my lord, as far as back in somewhere in 1983, but the division bench said, make a khata in his name as you made it in respect to the other properties. But this court in 1983 in a writ petition ordered by the learned Chief Justice then. But this is what the
It
court
directed making of khata.
Yes,
It did not direct grant of title. The
But
land court, grant
title I
court
had.
speaks of,
I had title.
no, that we cannot
I had
assume.
title by a registered document of sale.
That itself is to be examined by the, whether
My sale deed is more than 1960.
ಯಾವ್ದು copy?
But annexure A, 1960 sale deed. I purchased this property
In
on
1960.
23/5/1960. I have a sale deed under which I purchased the property. But the authorities had not made khata in my name. Therefore, the father of the petitioner,
I had approached division bench said enter the khata.
yes, my lord, make a khata.
ಯಾವ್ದು ಇದೇ ಪ್ರಾಪರ್ಟಿನಾ?
ಇದೇ property.
ಎಲ್ಲಿದೆ ನಿಮ್ಗೆ ತೋರಿಸಿ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿರೋ ಪ್ರಾಪರ್ಟಿ ಯಾವುದು? ಇದೆ ಯಾವ ಪ್ರಾಪರ್ಟಿ?
This
The complaint is with respect of survey number 5, 6, 7 and 8, which is they acquired by the then state of Mysore for formation of Vayali Kaval as well as SP extension. To overreach that particular acquisition proceedings, this 1960 sale deed was executed. And then he remained silent for 23 years. After 23 years, he filed a writ petition to enter his name, and the BMP was placed ex parte, and an order was passed to verify and enter his name. Then contempt petition was filed. Then a statement was made that without prejudice to our right to title, their name will be entered in the revenue records. So this is the proceedings, my lord.
Correct.
If his entry into the property is unlawful, my lord,
When, as on which date?
as on the date of 1983, my lord,
When the act came into force?
the act is subsequently it has come.
Read section 7.
Yes.
How that section is interpreted by Justice, Honorable
Arvind
Justice Arvind Kumar.
Yes.
But act ಕೊಡಿ. Xerox ಮಾಡಿ ಕೊಡಿ ಯಾರು? ಚಿಕ್ಕದು. ಭಾಳ ದೊಡ್ಡದಿದೆ ಅದು. ಹಾ.
Constitution of Special Courts.
is constitution of special courts.
And this particular property is earmarked for the playground, my lord. And
I am
this
not a
particular
land
property-
grabber, my lord, as they say, my lord.
Kindly come to 2F. Read the definition.
Yes, sir.
If somebody is in possession of the land,
Yes, ma'am.
as on the date the act came into force,
Yes, ma'am.
arguably,
Yes, ma'am.
he will not fit into the definition of land grabber, and his occupation will not be land grabbing.
Yes. My lord, I will-
Just see,
Yes,
Nodi.
yes. Every activity of grabbing of any land without any lawful entitlement and with a view to illegally taking possession of such land or enter into or create illegal tenancy or lease and licenses agreements, construct unauthorized structures thereon for sale or hire or give such land to any person or rental or lease and license basis for construction or use and occupation of unauthorized structure, and the term to grab the land shall be construed accordingly. Now, his activity has to be understood, my lord. If my lords look into the report which has been sought by the land grabbing court, that particular report of the BBMP specifically says that his activity of land grabbing with reference to 96 document, when it has started. And that particular report has been placed on record before the land grabbing court also. And that aspect has to be taken into consideration by the land grabbing court. In the teeth of this particular provision, my lord, the land grabbing court has directed the BBMP to submit the report. When the BBMP was about to submit the report, because the commissioner also initiated the proceedings against them, because the khata was entered because it was a park, my lord. Even today it is a playground. And illegally, recently, my lord, by virtue of some proceedings, my lord, he tries to put the fencing. He is not in possession of the land.
One sentence adagine nilbek. Process madokala now.
Yeah, sir. So if my lord. Yes.
When he got title to the land in 1960s.
Yes, ma'am.
By virtue of registered sale deed.
Yes, ma'am.
Registration of a sale deed is a notice to public at large, including your client. You are for BBMP.
No, my lord.
You're for
I'm
the
a
private.
resident, my lord. I'm one of the resident. In fact, the resident initiate, BBMP remained silent, my lord. They did not take any action. Then we started giving the representation because it is a playground being used by everyone, my lord. Then he started putting the fencing. He tried to interfere.
You said that already.
Yes.
All that has happened.
Then what should be approached? The commissioner did not take any action. Then we approached the regional commissioner. Regional commissioner initiated the proceedings. That was stalled, saying that khata has been entered into. Then, my lord, these proceedings are all subsequent to this particular land grabbing court. The act which has come into force.
What activity?
The regional commissioner proceedings and
No, that's not it.
Yes, ma'am.
In the sale deed,
Yes, ma'am.
it mentions possession also.
Yes. My lord, the possession could not have been given at all because the possession.
No,
Yes, ma'am.
whether two aspects, you're mixing two aspects. Offense should be committed post enactment.
Yes, ma'am.
Do you agree with this?
Yes, ma'am. That is my statement in the complaint also.
Correct.
Yes, ma'am.
Now,
Yes, ma'am.
he is in the occupation of the land as the title holder by virtue of registered sale deed.
No, he is not in possession, my lord.
Huh.
It is open land even today.
No, we'll assume that he is not.
Yes, ma'am.
The title to the land
Yes, ma'am.
is with him
No,
only.
no, my lord. Title is with by virtue of a notification issued under section 4 and 9. Sorry, section 4 and 6. The title was with the government.
4 and 6.
Yes, my lord.
What
in
is
the
that?
year 1949 and 1959.
Which act?
Under
Which
the
is
Land
that date?
Acquisition Act.
When title is by virtue of which 4/6? You are wrong.
Yes, my lord. I am placed on record, my lord.
You are wrong legally. You are simply you are wrong. Title passes after the acquisition process.
Once.
Culminates into taking possession of the
Yes.
land. That is the law.
Yes, that has taken place, my lord. I have placed that.
Where
Yes,
has it taken?
yes, ma'am. I request my lords to kindly take the page number 18 of my statement of objection, my lord.
Page number 18.
18, my lord. That is the 4-1 notification issued on 28th March 1949, my lord.
That is for the City Improvement Trust.
Yes,
Board,
my
and
lord.
it was-
For the City Improvement Trust.
When the possession was taken.
The possession was taken, my lord. I request my lords to kindly take the page number 22, my lord, annexure R5, with reference to this particular land, my lord. Final survey number has been given. It is shown that it is a corporation vacant land in the
When
field
the
book.
possession was taken, how it was taken.
Yes, my lord. My lord, in the year 1959 and 1960, it has been taken.
Where is that?
My lord, this is the field sketch report, my lord. And in the report submitted by the BBMP to the land grabbing court, my lord, they have explained everything, my lord.
Now report has been filed.
Filed to the land grabbing court, my lord.
All right, number 1.
Yes, ma'am.
Number 2,
Yes, ma'am.
let him produce that sale deed
Yes, ma'am.
and judgment of the division bench
Yes, ma'am.
and move an application for discharge.
Yes, ma'am.
Otherwise, he will not be able to, because they may not be part of the report at all. And he will be disabled from placing all that on record. At the stage of taking cognizance.
Yes.
Generally,
Yes.
the documents which the accused may bank upon will not be looked into. They are not part of the record at all.
Yes. My lord, in
Now,
fact,
there is a registered instrument.
yes.
That you should, now let him move discharge application. Ordinarily, discharge should be on the basis of the material borne out by the record of the complaint.
Yes.
But we want to make a small departure, which
Yes.
as we have done in other matters.
Yes.
Let him produce the registered sale deed,
Yes.
the division bench judgment directing change of khata,
Yes, ma'am.
and other official records contemporaneously arising therefrom. and let him seek discharge. Otherwise, he will empty. He has to go there without any benefit.
Yes,
We'll do that.
That one aspect, I'm not disturbing.
But
the
once
case.
you argue, if we reject, even 227 will not be available to you.
I'm not on that.
Ah.
Only one small instance, but we had approached this court in a writ petition. And this court said that the BBMP was a party. My learned friend said we were not in possession at all. This court said that we are in possession of the property and also said
How possession issue arose before the writ court?
that this writ court came to the conclusion of a sale deed, partition deed, khata certificates, tax paid receipt.
Court can say these are the documents in which possession is stated to have been the.
Data partner, BBMP was directed when they made a galata and attempted to put up gates on the property. I had approached this court. But this court came to the conclusion that when the title is vest, it is for the BBMP to take specific stand in accordance with the specific relief act, etc. Kindly turn to page 150.
That's how we believe you.
This is what I said.
Unless you insist that we should not be.
No, I'm not on that.
We
Sorry.
have understood now.
Sorry,
Point is,
but this court held, made a mention like this. Nevertheless, since the matter is pending adjudication at the hands of Karnataka Appellate Tribunal in the revenue appeal filed with the respondent BBMP, it is hereby directed unless there is a declaration made by a competent authority court in favor of BBMP, BBMP shall not interfere in the property in question and shall not put up any board on the property unless there is a specific direction obtained by the BBMP in accordance with law. This is the observation made with a learned single judge. But this has attained its finality, but there's no appeal filed. But court comes to the conclusion that BBMP shall seek such a declaration of the title and possession over their property.
that act was not there when that judgment was rendered.
This judgment is rendered recently by
Recently.
this court
Whether
on
act-
28/7/2023.
But the judgment yesterday when I read, it does not refer to this act at all. Nowhere it
But on
refers
that
one
date,
sentence about that.
what happened is that on that date, these proceedings were not initiated.
Therefore, we are now.
What he did is, after when they suffered this order, he immediately went to land grabs.
No, we can't hold mini trial.
No, I'm not asking for a mini
Even
trial.
we cannot, because now you are at the stage of taking cognizance.
Yes,
Unless your case fits into one of the 5, 6 postulates
yes.
of Chaudhary Bhajanlal,
Yes.
we are not interfering. But now we want to show some concession to you, permitting you to move application under 9 of the 2011 Act, read with 227 of CRPC and seek discharge. We also permit you to produce the certified copy of the sale
Yes.
deed, certified copies of the judgment,
yes,
and the certified copies of records generated because of these two documents.
yes,
And seek discharge, where he also will be able to
yes,
answer other points.
yes.
Because there are some findings which may help you.
But I understand. I understand.
That's the reason. Barkali. Challenge in this petition is Kutwal.
Please.
To the order taking cognizance of the offense punishable under section 4 other, which is the charging section 4 of the
4 of the
2011 Act, full bari. First. Learned counsel appearing for the petitioner vehemently argues that his client holds a registered sale deed dated
8/8/1960.
8/8/1960. Kutonde ಹೇಳಿ.
Please.
8/8/1960.
8/8/1960.
Semicolon. Based on the said sale deed, he obtained orders at the hands of the writ court in writ petition bar writ appeal number. ಕುತ್ಕೊಂಡೆ ಹೇಳಿ.
Writ petition 3775 of 1983.
3775 of 1983.
83 dated
Followed by
23/3/83.
huh?
Dated 23/3/1983.
Disposed of on 23/3/1983.
1983.
Followed by writ appeal ಏನೋ ಒಂದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
Writ appeal ಅಲ್ಲ, ಅದು contempt ಹಾಕಿದ್ದಾರೆ.
Followed by
CCC 921 of 93.
CCC 921 of 2023.
1993,
Disposed of on
disposed of with a direction,
date ಹೇಳಿ ಸಾಕು.
please. 21/1/94.
21/1/1994, semicolon. The writ court has entered a finding as between his client and the BDA that BDA should not interfere with the BBMP,
Then call.
that the possession, that it shall not interfere with the possession of the subject property, semicolon. Pursuant to writ orders, comma, the khata also has been changed in favor of his client, semicolon. That being, please be seated.
On-
ನಾಯಿಂದ ಕೇಳಿದ್ರೆ ಕೂತ್ಕೊಂಡೆ ಹೇಳಿ. This is
On
not primary.
22/12/93, khata has been changed. 22/12/1993, khata was entered.
On 22/12/1993, semicolon. That being the position, his client would not, petitioner would not fit into the definition of land grabber, nor his act would fit into the definition of land grabbing as provided under the dictionary clause of 2011 Act. First off, so contending, he falters the cognizance order. First, next part. Learned HCGP appearing for your party, appearing for the state, for the state,
Amended as in a Karnataka land grabbing special.
As fourth respondent.
appearing for the fourth respondent. Private counsel appearing for the complainant before the special court, who happens to be third respondent, oppose the petition, contending that whether there is act of land grabbing and whether the accused has committed such an act or pure questions of facts, semicolon. The factual position can be ascertained only at the stage of, in the course of trial, semicolon. Now, cognizance having been taken, comma, stage is set for that, semicolon, and therefore no interference of this court is warranted at this stage.
Court below special court, my lord, it has granted the temporary injunction. They can seek for the rejection of the plaint.
That also. Mr. Deshpande points out that the special court has already granted an injunctive order, an order of temporary injunction dated,
Yes, 14th August 2023.
14 August 2023.
The ex parte.
Correct?
The ex parte.
Although ex parte, comma, the petitioner can seek variation of the said order. First, so contending, they seek dismissal of, they pray for the dismissal of petition. Next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly of the view that the petitioner can avail an alternate and equally efficacious remedy of discharge as provided under section 9 of the 2011 Act, read with section 227 of CRPC, as we have held in similar matters, wide. Wide number so and so between so and so. Okay. Learned counsel for the petitioner is expressing apprehension that ordinarily the prayer for discharge will be treated keeping in view the material on record of the complaint, and therefore his client will have some constraint in getting the justice at the hands of the special court. First off. Now that the petitioner has produced a copy of the writ court order and contempt court order pursuant to which there is change of khata at the hands of the BBMP. First off, the writ court makes some observation against interference of the BBMP in the subject property. First off, no prejudice would be caused to anyone should the petitioner be permitted to place certified copies of these documents on the record of the complaint for which we are granting leave here itself. First off, the application which the petitioner would be filing within 2 weeks from this day, seeking discharge, would be considered on its intrinsic merits, keeping in view the evidentiary material on record of the complaint and other material to be placed by the BBMP and by the petitioner, as we have observed now. First off, till such application is heard and decided, the personal presence of the petitioners shall not be insisted upon. First off, this too we have done in a category of similar cases. Vide. Allon judgment parkobeku. Adon kodbeka. Next one, in the above circumstances and with the above observations, this writ petition is disposed of, courts having been made easy, and all contentions of the parties being kept open, including the prayer for rescinding of the order of temporary injunction. Okay.
That permission. I'm so sorry. I made a mistake, so it's my duty to correct myself. Our GST matter, I misspoke. 18% is if they are recovering tax from me. Refund kodadidre, it's only a maximum of 6%. So 18%.
I felt somehow like that, but you said this.
No, 18%.
18% itala. At the interest admissible in law, with the interest at the rates admissible in law.
But that is in any way computed, Maras. That's what I was, in fact, if things have not refunded for 2 years, we may ask for refund for that entire period. So, very well. Great. I'm sorry, I wanted to correct myself. I didn't want to.
You will never make false statement. You may make wrong statement.
It was wrong.
One request.
One famous statement ಇದೆ Arnold time bidu. ಇತಿಹಾಸಕಾರ ತಪ್ಪು ಬರೆಯಬಹುದು ಸುಳ್ಳಲ್ಲ ಅಂತ. It applies to you also.
Only one request. The single judge of this court, on 28/7/2023 has observed, as against the BBMP with regard to possession.
Correct.
That observations would help us
ಅಲ್ಲೆಲ್ಲ ಮಾಡಿದ್ದೇವೆ ನಾವು. ಅದನ್ನ ಬರೆದಿದ್ದೇವೆ.
That has
not to interfere ಅನ್ಕೊಂಡು ನಾವು ಬರೆದೇವಲ್ಲ. Single judge has said not to interfere. BBMP should not interfere with the property.
Yes,
I'll just one sentence. I have given that dictation. It's there.
That is at annexure U.
All right. ಅದನ್ನೆಲ್ಲ ವಸ್ತು ಕಂಟೆನ್ಷನ್ ಅಲ್ಲೇ ತಗೊಂಡ್ಬಿಡಿ. Okay. ಅಲ್ಲೇ ಕಾಗ್ನಿಜನ್ಸ್ ತಗೊಳ್ಳುವಾಗ ನಿಮ್ಮ ಎಕ್ಸ್ಪರ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ ಅದನ್ನ. ನಿಮ್ಮನ್ನೇನು ಹೇರ್ ಮಾಡಿಲ್ಲ ತಾನೆ? Okay.
In this case, only 2 weeks time may be granted.
18. ಯಾಕೆ ಏನೋ ತೊಂದರೆ ಇದ್ರೆ ಟೈಮ್ ಕೊಡ್ ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ಸೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
Compliance to be done within 10 days, failing which petition stands rejected.
I'm appearing for the petitioner in this matter, Your Lordship. This petition has been filed seeking the quashing of the arrest warrant issued by the Honorable State Consumer Forum. The facts of the case are that the respondent filed a complaint before the Consumer Forum alleging that the petitioner herein and 2 other
Where is the order?
At annexure A, your lordship.
ಏನದು?
Uh, the,
You are JDR.
yes, I'm the JDR. I'm the opposite party, number 2 in the original petition and the JDR number 2.
Ah.
So in this matter, the facts of the case are that the respondent had filed a petition before, a complaint before the consumer forum alleging that he had entered into an agreement with 3 opposite parties, out of which the petitioner herein was opposite party number 2. This was pertaining to the sale of purchase of a property worth 42 lakhs. Now the complainant or the respondent alleges that he had already, out of the 42 lakhs, he had already paid a sum of 15 lakhs, in spite of which the opposite parties had not executed a sale deed in his favor. Therefore, he approached the consumer forum. Now, in the course of the matter, after hearing the parties, the consumer forum
Come to page 21 and read the order. Complaint is allowed.
Yes, the complaint is allowed. The opposite parties are directed to execute a sale deed in respect of site number 1 as per old plan, which is site number 56/1, 56/2, 57/7 and 7/17 situated at Nachanahalli village, Kasaba Hobli, Mysore Taluk, Mysore, by receiving the balance amount from the complainant, if any. Further, the opposite parties are directed
1
to
lakh rupees to be paid.
Sorry, your lordship.
1 lakh rupees to
Yes,
be paid.
1
Next.
lakh is compensation and 25,000 as litigation expenses. Now, your lordship, I will come to this point, your lordship. First of all, pursuant to this, the respondent initiated execution proceedings in which the petitioner herein was arraigned as opposite party, judgment debtor number 2. Now, the opposite, the petitioner appeared through his counsel filing a memo of appearance, but on this very same date, without giving an opportunity to the judgment debtors therein to issue, to produce a statement of objections, the Honorable State Commission issued an arrest warrant.
Is it within 2 years?
What?
That order, it was allowed. Suppose if decrees, execution is levied for a decree within 2 years, no question of notice at all.
Your lordship, notice was issued. The petitioner appeared as well, not through.
What is the objection? Your objection, tell us first. You are in the
Your
report
lordship,
now.
first of all, in respect of this matter, the petitioner is not, there is no privity of contract between the petitioner and the respondent.
That does not arise now. There is an order.
Yes, your lordship, but this order does not specify, this order states that the respondent has paid the money. The order does not specify who the money was paid to. It was paid to the other opposite parties.
All those contentions were available to you before the consumer forum, not now.
Yes, your lordship.
There is an order now as against you. You have to comply with that order.
Yes, your lordship. We are in fact in the process of challenging that order.
You challenge it.
Yes, your lordship. Currently our contention is that the arrest warrant was issued, the arrest warrant that has been issued, it has been issued without giving us an opportunity.
We are asking you now, what is the opportunity? Assume that we are giving opportunity. Tell us now.
Yes, your lordship. In that case, that is the thing, your lordship. The order has been issued. Again, the amount that was paid by the respondent was paid to the opposite parties number 1 and 3. We are not in any way involved in the purchase of the, sale of the property. In fact, we are also a buyer of one of the properties, your lordship. We are upon a misunderstanding of facts, the respondent has filed a case against us. But
you file appeal against this.
Yes, your lordship, we will file
here.
that. But your lordship, in a similar, the other judgment debtors in this have at page number 38, they have filed a petition before this honorable court and they were granted a stay in this matter. And in a similar, that is at page number.
This matter along with WP number tomorrow. Monday.
Your lordship, in that a stay was granted. Kindly grant a stay.
No. You see, interim order is based upon the facts brought before the court, not this way. There is others may be party to this. That does not mean the relief granted to them should be granted to you. There is already an order as against you.
It is against the same parties that have approached this court in the other petition.
Call
Your
this
lordship,
matter along with WP.
Your lordship, another submission, your lordship. At annexure E, that is at page number 32. This honorable court has passed an order stating that on the similar facts, it has stated that the Honorable State Commission should not have issued an arrest warrant against the parties therein without, against the judgment debtors therein, without have giving them an opportunity to file their
No, we
objections.
don't agree with this. We are in division bench now. We don't agree with this judgment. We'll say that.
Yes, but in a similar relief was granted to the other judgment debtors, your lordship, and they were asked to, they have also, the rights of the respondent are protected. They were asked to
You
give a,
can, what we can do is, you have to file appeal against this.
yes, we are in the process of doing that, your
Process
lordship.
under arrest process.
This is kindly grant a stay on this matter, your lordship. We will,
No case is met. The challenge
the
is,
other judgment debtors
to
were
the
granted a stay in
order.
this.
We'll
matter.
consider that also. The, this petition seeks to, filed under Articles 226 and 227 of the Constitution of India, seeks quashment of the order dated 30/11/2024, passed by the State Consumer Dispute Redressal Commission in EA 63 of 2024, whereby execution is levied by arrest and detention of the petitioner, who happens to be one of the judgment debtors. Who happens to be one of the judgment debtors. First one, please be seated. Learned counsel for the petitioner vehemently argues that the order of the consumer, State Consumer Commission dated 29 May 2024, allowing consumer complaint number 626 2017 is being challenged before appropriate forum, and in the meanwhile the execution has been levied without opportunity of hearing to his clients, and therefore the this court should grant interference. First, having heard the learned counsel for the sentence, she also submits that in a connected matter, namely WP number
32520 of 24.
32520 of 2022.
24, your lordship.
24. Notice having been ordered, stay has been granted to the litigant therein, and therefore
Your lordship, one submission. In that, while granting stay, this honorable court has directed them to deposit the sum of 42 lakhs, which has already been deposited. So in that context, the rights of the respondent are protected, your lordship.
1 lakh, 3 sale deeds you have to execute, in respect of these properties. One sale deed.
Yes. Your
That you have not done.
No, your lordship.
Then-
That is pending consideration.
If you deposit the rupees 1 crore here, we will grant you similar order.
Your lordship.
Yes. ಹಂಗ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಪಾಪ ದುಡ್ಡು ತಗೊಂಡು ಸೈಟ್ ಮನೆ ಕಟ್ಟಿಗೆ ಹೋಗಂತ ಹೋಗಿರ್ತಾರೆ ಜನ ಬಿಲ್ಡರ್ಸ್ ಎಲ್ಲ ಹಂಗ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ವೇರ್ ಪೀಪಲ್ ಶುಡ್ ಗೋ.
Your lordship, we have no authority to execute the sale deed because the money was not paid to us. We have.
You have that is rightly, and if you want relief, you deposit rupees 1 crore here, I will grant you the stay. Otherwise you are not. Where the aspirants of sites ಎಲ್ಲ ದುಡ್ಡು ಕೊಟ್ಟು ತಗೊಂಡು ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅವ್ರು ಎಲ್ಲ ಬಡವ್ರು ಇರ್ತಾರೆ, ತಮ್ದು ಇಡೀ ಜೀವನ ತುಂಬಾ ದುಡ್ದಿದ್ದನ್ನ ಅಲ್ಲಿ ಹಾಕಿರ್ತಾರೆ ಮನೆ ಕಟ್ಟಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ.
Lordship,
ಅದೇ ಬಿಲ್ಡರ್ಸ್ ಇವ್ರಿಗೆ ಏನಿರ್ತದೆ ಎಲ್ಲ ಆ ರೀತಿ ಮಾಡಿಬಿಟ್ರೆ.
ಬೇರೆ opposite parties execute ಮಾಡ್ಬೇಕು
ಅಲ್ಲ,
ನಮಗೆ.
if you agree, we do that, otherwise we are dismissing that. What we should do? Option is yours. If you are ready to deposit rupees 1 crore, we'll give you some time also. Deposit in the registry. If you succeed, you will get back that money. We are not giving it to anybody.
Lordship, a smaller sum.
50 lakhs, there we call that. Issue emergent notice. Stay as prayed for, subject to petitioner depositing rupees 50 lakh in 2 equalized weekly installments, failing which not only interim order stands automatically rescinded, but petition itself runs the risk of dismissal.
Your lordship, kindly grant a 12.
No, he's a builder. He's not other. agriculture ಇಷ್ಟು laborer ಇದ್ರು ನಾವು ಟೈಮ್ ಕೊಡ್ತಿದ್ವಿ. He is a builder. Yes. In the registry of this court ಅಂತ. ಹಾ. ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್ ಬನ್ನಿ. ಇಲ್ಲೇನೋ ಹೇಳ್ತಾ ಇದ್ರು ಕೇಳ್ಕೋಬೇಕು.
Your Lordship, in view of that, I've already submitted at annexure F, they have already been filed another petition before this court, hence we did not make them a party to this, therefore kindly.
ಪಾರ್ಟಿ ಮಾಡಬೇಕು.
I will.
Petitioner is permitted to array response numbers 1 and 2 before the consumer forum as respondents 2 and 3
Yes.
to this petition. ಮಾಡಿಕೊಡಿ ಇಲ್ಲೇ. Issue emergent notice. Stay as prayed for subject to this one. Call this petition along with WP number. Pending ಇದೆಯಾ ಅದು?
3252.
All right. But yes,
Bring for the petitioner, my lord. Well, serial number 20 and 22 both are connected, my lord.
20 and
22, my lord.
22.
My lord, I'm before this honorable courts challenging the order passed by the State Consumer Commission, my lord. My lord, I have filed an appeal before the State Commission, where in District Commission I was being placed ex parte, my lord. I was only aware of that fact in September 2024, my lord, when the decree holder.
Objection.
Yes, my lord.
Second settle.
My lord.
Office objection. ಇನ್ನು ಅವ್ರಿಗೆ ಬೇಡವಾ? ನಮ್ಮ ಬ್ರದರ್ಗೆ ಹೆಂಗ್ how to share the papers? It's not like a cake.
In the serial number 22, both copies have been served. I'll just make my preliminary submission.
Yeah, preliminary comply ಮಾಡ್ರೆ ಮುಂದೆ ಕೇಳ್ತೇವೆ ಇಲ್ಲೇ ಇರಲಿಲ್ಲ. Post this matter after of compliance of office objections. Yes, ಅದನ್ನ ಇದನ್ನ along with each other. Yes, next.
My lord, in this case, I've challenged the DRAT order, my lord. It is, I'm supposed to deposit 50% of the time, initial amount, my lord. If 8 weeks time is granted, I'll deposit that amount and I'll.
Section 17, huh?
18, my lord, 18, my lord. I've paid, my lord. I've complied, that other objection I'll comply, my lord. Within due course, I'll comply.
ಅದೀಗ appeal dismiss ಮಾಡಿಲ್ಲ ಇನ್ನು.
Dismiss, my lord.
Appeal dismiss ಆಗಿದೆ.
Dismiss ಆಗಿದೆ. The order is itself clear, my lord.
ಎಷ್ಟು ಅಮೌಂಟ್ ಆಗ್ತದೆ ಅದು?
18,54,577, my lord. 8 weeks time may be granted.
Actually ಕೊಡಕ್ ಬರಲ್ಲ. ಇದು complaint of office section second time.
Out of that 25% I'll deposit within 4 weeks.
ಸೈನ್ ಮಾಡಲ್ವಾ? Post after complaints. Yes.
2 days time maybe.
So whenever you comply, we do. Signature ಮಾಡಲ್ಲ. Court fee ಕೊಡಲ್ಲ, signature ಮಾಡಲ್ಲ, ಏನು?
Appealing for the petitioner, my lord, this is complied, my lord.
Execution petition copy ಹಾಕಲ್ವಾ? ಕಾಪಿ ಬೇಕಲ್ಲ?
I have not received the copy, my lord.
ಅಲ್ಲಿ ತಗೊಂಡು ಹಾಕೋರು ಕೊಡ್ಬೇಕು. ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ತಕ್ಷಣ ಹಾಕ್ಬೇಕು. ಏನಾಗಿದೆ ಈಗ?
My lord, here I am challenging the application filed under section 5 of Limitation Act, my lord.
5 of Limitation
Act. My lord, the fact is it.
ಅವ್ರು ಹೇಳಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡ ಅಂತ ಹೇಳಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಕುತ್ಕೊಂಡು ಓದು ಅಂತ ಹೇಳಿ ಮಾತಾಡೋ ಬದ್ಲಿ. Yes.
16/12/2023, my lord. The order was passed by district consumer, my lord.
16/12/23.
My lord.
Correct.
And after the order has been passed, execution proceedings were initiated, my lord. Here, my lord, in district consumer, I was placed ex parte claiming that I have received the notice and not appeared before the court, my lord. I was aware of that fact in September 2024, my lord, when the decree holder tried to file an FIR against me before the police station, HSR layout police station, my lord. Only then I was called to the police and then I was completely made aware of all the proceedings in district forum. Until then,
notice ಬಂದಿತ್ತಲ್ಲ ನಿಮಗೆ?
Illa Swami, that is what I had. I am actually filed an RTI before the postal office. I have not signed it, my lord. I have not received it. That is my contention. I have not received the notice itself. I have a very good case on merits to contest, my lord. I filed an appeal before the state commission. I have a very good case on merits to contest this matter, my lord.
ಈಗ ಏನಾಗಿದೆ?
My lord, the state commission has dismissed my appeal, stating that the appeal is time barred, my lord.
You were a party to that.
Yes, my lord. In the district commission.
Another sentence ಗೆ ಉತ್ತರ ಕೊಡ್ಬೇಕು. You were a party to the proceedings.
proceedings to the district commission.
That's what.
I was party, but I did not appear because I was placed ex parte, my lord.
You are placed ex parte.
Ex parte in the district commission. In state
Your-
commission, I preferred my appeal.
Your case is that you are not served with the notice.
Yes, my lord.
ಏನದು ಇದು ಆರ್ಡರ್ ಫೈನಲ್ ಆರ್ಡರ್ ಏನಿದೆ?
Of the state commission, my lord. Page number 23.
No, that is dismissal ಆಯ್ತು.
Yes, my lord.
Consumer forum
In
ಏನಿದೆ?
the consumer court, my lord, it is in page number 14. The opposite parties.
1 lakh for
1
the
lakh.
deficiency
Yes, my lord.
and cost of litigation 5,000.
Yes, my lord.
You
I-
deposit 50,000 rupees here.
I had deposited 50,000 in the state commission also, my lord.
Deposit ಮಾಡಿರಾ ಈಗ?
Yes, my lord. I have deposited 50,000 in
Emergent
state
notice.
commission.
Interim order as prayed for. First off, this unconditional interim relief has been granted on the assertion of counsel for the petitioner that his client has already deposited a sum of rupees 50,000 in the registry of the State Consumer Forum.
Yes, my lord.
Okay. Next.
My lord, serial number 20, my lord.
Application kodi.
I'll produce, my lord, in next.
The order shall be released. This order shall be released only after compliance of the office objection and not otherwise. Yes.
My lord, this same matter is connected with 20, same, my lord. The two consumer
ಅದು
complaints.
ಒಂದೇ ಕಾಪಿ ಇದೆ. ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಲ್ವಾ ಕೋರ್ಟಿಗೆ?
Swami, ಕೊಡ್ತೀವಿ,
ಮತ್ತೆ? Next.
Grateful,
Huh?
grateful, grateful.
233 days delay, my lord.
Your lordship, I
Yes,
appealed for the respondents in this matter. Your lordship, we have not been served with a copy of condonation of delay application.
ಯಾಕೆ application
Directions may
ಕೊಡ್ತಾ
kindly
ಇಲ್ಲ?
be given.
So ಮಾಡಿದೀವಿ.
ಒಂದು ಕಾಪಿ ಕೊಡಿ. At least formally they should know.
We
We
have
may be
served.
lenient, but ಆ ಕಾಪಿ ಆದ್ರೂ ಕೊಡೋದು ಬೇಡವಾ? ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಪ್ರೂಫ್ ಕೊಟ್ಟ ಬಗ್ಗೆ? ಎಲ್ಲಾ ಕೇಸ್ನಲ್ಲಿ you are not serving the copy at
ಇಲ್ಲ
all.
ಆನ್ಲೈನ್ ನಲ್ಲಿ ನಾವು ಇದು ಮಾಡಿದೀವಿ, ಕಳಿಸಿದೀವಿ.
ಎಲ್ಲಿ ತೋರಿಸಿ? ತೋರಿಸಿ ಯಾವಾಗ ಕೊಟ್ಟಿರ್ತೀರಿ? ಅವ್ರಿಗೆ ಕಾಪಿ
Only the
ಎಲ್ಲರೂ ಯಾಕೆ ಸುಳ್ಳು ಹೇಳ್ತಾರೆ? Why all lawyers will lie? ಕಾಪಿ ಕೊಡಿ. ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. Appellant to serve copy of the condonation of application for condonation of delay on the counsel appearing for the respondent assessee immediately. Okay, call next week.
much obliged.
This matter, my lord, by mistake, my lord, we have already filed the appeal against our impugned order. Second time ಅದಾಯ್ತು. So this we are
Will not
withdrawing.
survive. You withdraw that.
We are.
Counsel, senior panel counsel appearing for the revenue submits that already the same order impugned in this appeal is impugned in ITA number
332,
332 of 2023.
23.
And therefore, this duplicate challenge be disposed of as being unnecessary. First, we agree with this. Ordered accordingly. Next. Accordingly and appeal is disposed of. Calibri vehicle. Okay. Please. 25.
There is a delay of
Yes, sir.
225 days delay, lordship.
Yeah. Appeal is, the petition is moved after booking a delay of 225 days. First off, an application in IA number 1 of 2023 supported by affidavit is moved seeking condonation thereof. First off, no objections are filed to the same from the other side. First off, a plausible explanation is offered for condonation of said delay. First off, in the above circumstances, application having been favored, delay is condoned. Yes.
Next matter, lordship, 416 days.
Yeah. ಯಾರು? ಇದಕ್ಕೇನಾದ್ರು
Please,
some books ಕೊಡ್ಬೇಕು. ಇಷ್ಟು
Please.
ದಿವಸ 100-200 ದಿವಸ ಆದ್ರೂ ಮಾಡ್ಬೋದು.
please,
400-800 ದಿವಸ ಇದ್ರೆ ಒಕ್ಕಟೆ ಮಾಡಕ್ಕಾಗಲ್ಲ.
please,
ಯಾವ ಬುಕ್ ಕೊಡ್ತೀರಿ?
please, lordship.
Which book you will give to the library, the advocates library?
As your lordship orders.
ಅಲ್ಲಿ ಹೇಳಿ, ಯಾವ್ದಾರ ಒಂದೆರಡು ಪುಸ್ತಕ ಹೇಳಿ, ಒಳ್ಳೆ ಕಾನೂನು, ಒಳ್ಳೆ ಗ್ರಂಥಗಳನ್ನು ಹೇಳಿ. ಅದನ್ನ ಕೊಡೋಣ ನಾವೇ ಕೇಳೋದು.
The GST Act, Your Lordship.
ಅದಿದೆ GST ಆಕ್ಟ್ ಎಲ್ಲ ಬೇಕಾದಷ್ಟಿದೆ.
Please.
ಒಳ್ಳೆ ಯಾವ್ದಾರ ಪುಸ್ತಕ ಹೇಳಿ.
ಅವ್ರು ಏನೋ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾರ.
ಹಾ ಹೇಳಿ ಯಾವ್ದಪ್ಪ?
ರಾಜಧರ್ಮ by justice
ಯಾವುದು? ಲೀಗಲ್ ಅಂಡ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಲೀಗಲ್ ಹಿಸ್ಟ್ರಿ.
ರಾಜಧರ್ಮ
ರಾಜಧರ್ಮ ವೆರಿ ಸ್ಮಾಲ್ ಅದು, ಎಷ್ಟಿದೆ ಅದು.
contains good
ಅಫ್ಕೋರ್ಸ್ ಅದು ಇದೆ, ಹಾಗಾದ್ರೆ 1 ಡಜನ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಅವ್ನು. ವೆರಿ ಸ್ಮಾಲ್ ಬುಕ್.
Lordship, ತಮಗೆ ಫುಲ್ ಇದು ಇದೆ, ಒಳ್ಳೆ ಬುಕ್ಸ್ ಇದ್ದು ತಾವೇ ಹೇಳಿದ್ದು ನಾವು ಕಂಪ್ಲೈ ಮಾಡ್ತೀವಿ.
ನೋಡಮ್ಮ, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಬೇಕು. ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಈಸ್ ಅಲೋಡ್ ಅಂಡ್ ಡಿಲೇ is condoned subject to the condition that the petitioner shall present a set of 2 books, Constitutional and Legal History of India by Justice M. Rama Joyce to the Association Library. First, ಇದು ಇರಲಿದ್ರೆ ಏನು ಕೊಡ್ಬೇಕು, ಮತ್ತೆ ನಮ್ಮ ಮುಂದೆ ಹಾಕ್ತಾರ ಅವರು. Within 2 weeks. Within 2 weeks. Failing which application shall be treated to have been dismissed. Okay. And as a consequence, petition itself would go.
Please, sir.
Okay.
Oblige. Please, sir.
Conduct.
I pray.
My lords, in this 2 weeks time for filing objections for both condemnation and
No, allowed, application allowed, delay condoned. Yes.
stay for 2 weeks for the stay application.
Call after 2 weeks. 512 ಇದೆಯಾ? ಹೌದಲ್ರಿ?
512.
512 ಇದೆ.
Please.
ಯಾವ ಬುಕ್ ಅನ್ನು ಕೊಡ್ತೀರಿ?
Lordship may suggest 2 books, Your Lordship.
5 books.
5.
ನೋಡಪ್ಪ, ಬೈ ಶಾಂತಿ ಭೂಷಣ್, ಕೋರ್ಟಿಂಗ್ ವಿತ್ ಡೆಸ್ಟಿನಿ, ಅವರ ಬಯೋಗ್ರಫಿ, ಆಟೋಬಯೋಗ್ರಫಿ ಚೆನ್ನಾಗಿದೆ. ಟು ಅಸೋಸಿಯೇಷನ್ ಲೈಬ್ರರಿ ವಿದಿನ್ 2 weeks. ಓಕೆ, ಪ್ಲೀಸ್. ಅಲ್ಲಿ 3 books ಮಾಡಿ, 3 books. ಆಲ್ ಕೊಡಿ ಕೊಡಿ. ಪಾಸ್ವರ್ಡ್ ಇಲ್ಲ.
My lords, I appear for the petitioners, my lords.
Petitioners are. Pickup ಬಂದ್ರೇನು?
My lords, in Urdu it means camels.
Camel.
Camel.
Okay.
And he is the first Tirthankara of Jainism, my lords.
Lord of 27, he is first.
He is the first. my lords.
24.
Lord Mahavira is 24th.
24th. Rishabha is also one of the Tirthankaras.
He is the first one.
First Tirthankara.
Rishabha or Rikab.
That way. Okay. But Rishabha in Sanskrit means ox.
Ox.
Yes.
My lords, I am for the petitioners, my lords. Petitioner are home allottees and decree holders before the national consumer, my lords. Annexure A is the warrant of attachment which has been issued, my lords. And the respondent number 2 and 3 are the executing authorities, my lords. This warrant was issued in February 2024, my lords, and so far it has not been executed, my lords. So my limited prayer is writ of mandamus, my lord, to execute the
The
warrant.
short grievance of the petitioners is as to long pendency of their execution application number.
Execution warrant at the warrant.
Warrant of attachment.
Yes, my lords.
We can say execution itself ಬೇಗನೆ ಮುಗಿಸಕ್ಕೆ ಹೇಳ್ಬೋಣ.
Execution warrant, my lords, before the deputy commissioner in Bangalore, my lords.
on pendency of accomplishing the execution warrant of attachment. Execution of warrant of attachment. Dated
Dated, my lords, 21st February 24.
21 February 2024. First. Learned HCGP on request appearing for the official respondents
1, 2, and 3.
1, 2, and 3. And notice to private respondents
My lord,
having
4 and 7 may be dispensed at my risk, my lord.
been dispensed with. Comma. Submits that she would speak to the concerned officers to expedite the execution process. First. Next one, in the above circumstances, this petition is disposed of, fixing a period of 8 weeks
Please, my lord.
for accomplishing the task of execution.
Highly obliged.
First, all contentions are kept open. Registry to send by speed post a copy of this order to the all other response for to so and so.
Obliged.
Rahul Gandhi, Rahul Shah versus so and so. Okay. Call next week to enable counsel, of call after 2 weeks to enable counsel for the petitioner to come and argue.
My lordship, in this, I'll sort short accommodation by Monday or the tomorrow, my lordship.
Call
Because
next
there's
week at the request of,
I'm sorry, I was not there on the earlier occasion, 2 days back. I was
even
on-
if it is tomorrow, but that's. the
tomorrow
bench-
bench alla, barli, next week.
Please, please.
Entry order ideyalla?
ಹೌದು.
Call next week at the request of learned CGP. First of entry order to continue till then.
My
Till
lord,
next date of hearing and.
17th, 16th, my lord.
Call
please.
16th.
I'm
Call on
grateful.
16th. Okay. Yes, Madhukar.
The candidate is before my lords. Yeah, he is challenging the order of the DRT as well as DRAT, my lord.
Yeah.
He filed an application before the DRT, my lord, to defer the proceedings of the pending before the DRT till the disposal of the suit which he has instituted as a guarantor, and alleging that, my lord, there is a fraud and collusion between the borrower as well as the bank employee. And one more contention what I had taken in the suit is that, my lord,
Who are you? You are borrower,
I am not the borrower, my lord, I am the guarantor.
guarantor.
Yes, my lord. One more contention what I have taken is that, my lord, by virtue of a collusion and fraud, I am completely discharged from all the liability as per the provisions of the Indian Contract Act.
That you have to judge ಅಲ್ಲಿ
In the suit, I have to.
ಅದನ್ನ ಆಗ್ಲಿ.
Yes, my lord.
In the event you succeed in the suit,
Yes,
you
ma'am.
can get back that money from the bank. The bank is a huge bank.
My lord, my submission is that, my lord, with respect of the very same contention on which DRT has dismissed my application, with that contention, they sought for the rejection of the plaint before the civil court, my lord.
ಅದನ್ನ independently consider ಮಾಡ್ರಿ ಅಂತ observe
That application came to be allowed, my lord. Then appeal was preferred by me before this honorable court. In appeal, extensively, the court has considered the contention of the parties as well as the documents, my lord. The court has come to a conclusion that this question has to be thrashed out by the civil court, and the rejection of plaint is not permissible. My lord, here in this particular case, my lord,
how can statutory tribunal be directed to defer the proceedings till the object is not that?
Yes,
Object is.
to that extent, my lord, I am relying upon Mardia Chemical, my lord. In Mardia Chemical, my lord, yes,
Sorry.
yes, I have filed a judgment compilation, my lord. That is on 11/6/2024, I have filed the.
Who is your lender?
My lord, the lender is, my lord, Lakshmi Vilas Bank, my lord. Later, my lord, the Reliance has taken over. Now presently it is Reliance Assets Reconstruction Company.
Yes.
My lord, it starts at page number 3, my lord. The relevant paragraph, my lords would find at page number 41, para 51, my lord. Page number 41, my lord, para number 51. What is the scope of a suit, my lord, that was considered by the court at the instance of the Union of India, my lord? Then the court came to a conclusion that insofar as collusion is between the party and fraud is between the party, to that extent, the party can approach the civil court and seek his redressal of grievance. Because the debt recovery tribunal
Fraud is played by whom?
Fraud is played by the bank officials and borrower.
Borrower.
Yes, my lord.
You
My
proceed against them.
Sorry, my lord.
No bank official,
yes, my lord,
when he commits fraud,
yes, my lord,
that fraud is not of the bank.
No, no, my lord. There is a decided judgment, my lord. It binds the bank, my lord.
Huh?
In Canara Bank judgment, my lord. Then yes, my lord. That is my submission is that, my lord. It binds the bank, and the bank is supposed to initiate the proceedings against him. The guarantor or other persons cannot suffer to that extent, my lord.
No, if fraud is committed,
yes, my lord,
both by the, according to you,
yes, my lord,
both by the bank and the principal borrower.
yes, my lord,
Is it not?
yes, my lord,
In the event you succeed in that suit,
yes, my lord,
you can recover this money from the bank. We'll make the bank subject to that one only.
my lord. In that event, my lord, the similar question was before the Delhi High Court, my lord. In that particular proceedings, my lord, the same situation. The Delhi High Court directed the completion of the suit, my lord, in a time-bound proceedings. Already we have reached the stage of evidence, my lord. My further evidence, it is
Take emergent notice. No entry model.
An entry order is there, my lord.
Is
Already
for the bank.
it extensively matter.
Bank, my lord, I filed a detailed objection. I'll just point out, my lord, two aspects before this on code. It is not in dispute, my lord. They availed the loan by the petitioner. I'll just point out, my lord, two documents, my lord, may kindly, my lord. What had happened, my lord, in the year of 2010? The petitioner, along with, my lord, the principal borrower, Srijan petition, approached the bank, my SNE bank. Later, my lord, the 2011, I'll just point out that one document, may kindly see, my lord. It's in open eyes, they executed certain documents and that to registered documents. In my statement of objections, which I filed, my lord, on dated 29/5/2024. It's not so, my lord. Made chemicals is only in respect of surface. It's not in nothing to do with, my lord, OA proceedings. My lord, my entire OA proceedings, I have to record more than 81 crore, my lord, it's stall. My lord, kindly come to, my lord.
Your objections.
Objections, my lord, page number 23. It is executed by the very same petitioner that to registered. My lord, in respect of the scheduled property at, my lord, page number 25.
ಏನಂತ ಹೇಳಿದಾರೆ ಅವರು?
My lord, in fact, they executed a mortgage at the instance of, my lord, the principal for Sujan precision for, my lord, kindly come to, my lord, that and that 7.5 crore rupees, my lord, kindly come to para 3, para 2 in the, my lord, memorandum of deposit of title deeds.
Page number?
Page number, my lord, 23, document number 1 in my statement of objection.
23.
Also,
This is a registered instrument.
registered instrument because subsequent documents, my lord, I'm so sorry.
ನಾವು ಎಷ್ಟು ಕೇಳ್ತೇವೆ ಅಷ್ಟಕ್ಕೆ ಹೇಳಿದ್ರೆ ನಮಗೂ ಅನುಕೂಲ ನಿಮಗೂ ಅನುಕೂಲ. ಮತ್ತೆ ನೀವು ಹೆಚ್ಚಿಗೆ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ನಾವು ಬೇರೆ ಬೇರೆ ಕ್ವಶನ್ಸ್ ಕೇಳಬೇಕಾಗತ್ತೆ. ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳೋದು?
My lord, para 2, my lord, the petitioner,
This guarantee.
ಹೌದು ಅಲ್ಲ ಗ್ಯಾರಂಟಿಗಿಂತ ಮುಂಚೆ, my lord, mortgage ಗ್ಯಾರಂಟಿ ರಿಜಿಸ್ಟರ್ಡ್ ಅಲ್ಲ. Mortgage deed is page number 20.
We.
Since, my lord, the Varadaraj Achar, is a present petition before the honorable court, executed the mortgage deed in favor of the bank. Foreign rupees of, my lord, 7. My lord, para 2 ನಾನು ಓದ್ತಾ ಇದ್ದೀನಿ in favor of first Lakshmi Vilas Bank, SNE Bank. Second para, we mortgagor have already deposited the title on so and so and so. Mortgagor Koramangala branch, the following documents of title relating to mortgage property listed here under schedule A, so and so so and so. Mortgagor measures Srijan Precision Components Private Limited, so and so. Open cash to so and so in limits of rupees not exceeding rupees 7.5 crore rupees.
Correct.
And, my lord, next document, my lord, they executed, my lord, guarantee, letter of guarantee. And, my lord, what had happened, my lord, later? Up to, my lord, 7.5 crore rupees, which
the registered mortgage is not in dispute. I'll point out from their own written statement filed before the DRT.
In that suit, are you a party?
Yes. ಹೌದು ಅವ್ರ ಪಾರ್ಟಿ ಈಸ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 9
ನೀವು
ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸರ್ಫಿಸಿ. Milord, there are, Milord, I'll just two more points.
Next.
Milord, then, Milord, it's 7.5 crore to it become 10 crore enhancement taken place. And Milord, later, Milord, in the year of 2014, 29/11, 2014, that account become NPA. Milord, kindly appreciate 2010 is the first loan. 2011, there is a registered mortgage and guarantee when enhancement taken place. 2014, 29/11, 2014, Milord, they are not here the terms of Milord contract, that account become NPA. My assigner bank filed the original application on 1/1/2015 before the DRT.
This mortgage DD dated
Milord,
25/7/2011.
11. Milord, on 29/11/2014, that account become NPA. Immediately, my assignee bank filed the original application before DRT. That is, Milord, Annexure C. I'll just point out, Milord, that one document. Page number, Milord, in the petition which filed by Milord petitioner.
Nidan. Hold back. We have already deposited on 27/2011 at Mortgagees Koramangala branch the following documents of title relating to so and so. For the purpose of second, this is registered instrument.
It's not in dispute.
The letter of guarantees, document 2.
ಹೌದು ಫಸ್ಟ್ ಒಂದಿದೆ ಎರಡಿದೆ ಡಾಕ್ಯುಮೆಂಟ್. ಹೌದು ಎರಡಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 2.
ಅದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಇವರು?
ಅದರಲ್ಲಿ Milord, kindly come to Milord, page number 33. So and so I am liable to so and so the enhancement ಆದಾಗಲೂ so and so amount ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇನ್ನೊಂದು ಗ್ಯಾರಂಟಿ ಇದೆ. That is also I'll just point out. There are two guarantees, Milord.
33.
ಹೌದು ಅದಕ್ಕೂ they admitted that, Milord, I rate of interest page number 34 14% ನಾನು ರೇಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಗ್ರಿ ಆಗಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ what will happen, Milord, that account become NPA in the year of 2014. The date is
ಅದೇ ಫಸ್ಟ್ ಗ್ಯಾರಂಟಿ ಡೇಟ್ ಏನಿದೆ?
Sir, Milord, first Milord, in the mortgage date 20th/7/2011 is a mortgage deed.
ಅದಾಯ್ತು.
ಆವಾಗ ಅದು
ಲೆಟರ್ ಆಫ್ ಗ್ಯಾರಂಟಿ ಡೇಟ್ ಏನು?
ಆವಾಗ ಅದೇ ಟೈಮಲ್ಲಿ ಒಂದು ಮಾರ್ಕೆಟ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು. That, Milord, I am not produced here. And Milord, subsequent, Milord, when enhancement taken place, that is dated, Milord, my second document dated. No, Milord, it's also, Milord, at the time mortgage only. Mortgage deed, that second document, document number 2.
16/11 ಇದೆ ಅದು.
ಹೌದು
16/7.
ಹೌದು ಸರ್
2011.
ಹೌದು. In that para 3.
1 second. 16/11. This is 20 subsequent to this mortgage deed.
ಹೌದು.
You are right.
Idರಲ್ಲಿ sir, they admitted their liability and Milord, in fact, in respect of rate of interest also Milord agreed. At Milord, para number, page number 28, it starts from Milord page number 27, 28 first para. And Milord, page number 30.
30.
The last para. I understand as a precondition relating to grant of the loans advances for the non-fund based Srujan, that is principal borrower so and so and so, and furnishing of guarantee relation thereto, the Lakshmi Vilas Bank, my assigned bank, requires consent of the guarantors of the credit facility so and so by the bank disclosure of the information. The Milord, they consented for the loan.
Paragraph 12.1.
How sir?
What is the educational qualification of your clients?
He's a priest, my lord.
Huh?
He's priest. He has only studied up to 6th or 7th standard.
Anywhere you have stated in your suit or here?
My lord, in the the COD has investigated, my lord. In that investigation report, they have considered all those aspects. But in plaint, my lord, I have not mentioned his educational qualification, but his background I have mentioned, my lord.
What is the property worth he holds?
ಎಷ್ಟು 6,000 square feet.
ಅಲ್ಲ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ ಅವರಿಗೆ?
ಏನೂ ಇಲ್ಲ. My lord, one submission, my lord. Sorry.
ಒಂದ್ ಸೆಕೆಂಡ್ ನಾವು ಕೇಳೋದ್ ಬೇಡವಾ?
So sorry, my lord.
ಹಂಗ ಹೇಳಿದ್ರೆ ಹೆಂಗ್ ನಾವು ಮತ್ತೆ ಏನೋ ನಿಮ್ ಪರವಾಗಿ ಆಗುವಂತದ್ದೇ ಹೇಳ್ತಿರ್ತೀವಿ. ಇಫ್ ಯು ವಾಂಟ್, ಡು ನಾಟ್ ವಾಂಟ್, ಆಲ್ ರೈಟ್.
I apologize.
ಮತ್ತೆ ಅಷ್ಟು ಯು ಹ್ಯಾವ್ ಟು ರೆಸಿಸ್ಟ್ ಯುವರ್ ಟೆಂಪ್ಟೇಷನ್.
My lord, I admit, my lord, from page number 23 to 32.
You admit these
Yes,
documents?
my lord. These document I admit. I am not disputing these document, my lord. These are of the year 2011, my lord.
Correct.
It is a registered document. It bears my signature, my lord.
Correct.
The subsequent to this, that is in the year 2012, particularly from the August 2012, my lord, all those signatures are created
All
signatures.
right, we'll assume that they are all invalid.
Yes, my lord. My
What
sir-
about the transaction which you admit?
My lord, to that, my lord, para number 53 of the Mardia Chemicals is the answer. If there is a variance, my lord, that the Supreme Court has said that if there is a variance in particularly section 133 and 135 of the Contract Act, I am discharged. And that particular question, as per the Mardia Chemicals, my lord, it has to be decided by the civil court.
ಅದು ಡಿಸೈಡ್ ಆಗ್ಲಿ. ಈ ಅಮೌಂಟ್ ಅನ್ನು ಅವರಿಗೆ ಅದನ್ನು ಸಪರೇಟ್ ಆಗಿ ಇಡ್ಲಿಕ್ಕೆ ಹೇಳ್ತೇವೆ. ಒಂದು ಎಸ್ಕ್ರೋ ಅಕೌಂಟ್ ನಾಗ ಇಡ್ಲಿ ಈ ಅಮೌಂಟ್ ನಿಮ್ದು.
My lord, my only indulgence is that, my lord, there is one particular judgment of the
Delhi High Court.
Delhi High Court,
Which says dispose of the suit ಅಂತ. We
Yes,
don't agree with that. Give that.
yes. My lord, my
Otherwise statutory.
the amount, sorry, my submission is that, my lord, already, my lord, my evidence is over, my lord. And they have.
Anyway,
Yes, ma'am.
the amount will be put in escrow. We'll direct them to keep that amount in escrow account. So that tomorrow if you succeed, they cannot also use that amount. It should come to you. What else is
My
required?
lord, that is my livelihood, my lord. for
That
case.
cannot be. You should have thought when 1 to 32, which you have admitted,
Yes, ma'am.
before executing those documents, you should have thought of all that. Otherwise, public money.
My lord, I am not saying that I have not stood as a guarantor. As a good
Therefore-
faith, I have stood as a guarantor.
ಹೌದಾ?
Once,
ಈ ಗ್ಯಾರಂಟಿನೇ ಡಿಸ್ಚಾರ್ಜ್ ಆಗ್ತದೆ ಅನ್ಕೊಂಡು Mardia ಪ್ಲೇಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಲ್ಲ.
yes, ma'am.
We do not agree with
My
that.
my
We
lord,
have considered Mardia in 2 judgments. For the first time you are citing this judgment. In 2 judgments, I have considered Mardia. It's not that to that effect. Because you admit you are the guarantor. You admit you have given the property by way of security.
Yes, ma'am.
Subsequently, they have done fraud. Go against them.
My lord, that
You may
is-
succeed also.
I seek, I request my lords to permit me to read para
Read,
50.
read.
Yes, ma'am. My lord, the same compilation, my lord, which I was referring to, that is 11th June 2024, my lord. Page number 42, my lord, para 53, my lord.
Number?
Yes, my lord. Page number 42, my lord. The para 53, I will read, my lord. If my lords permits, I will. read
Yes.
it. Yes.
We also
We
find it
also find it
appropriate.
appropriate to mention at this stage that in reply to the submission made by so and so on behalf of the guarantors that even though a guarantor may stand discharged as envisaged under section 133 and 135 of Indian Contract Act, where any variance in terms of the contract has been made without his consent, then too guarantor may be proceeded against and he will have no right to raise an objection before measures have been taken against him under section 13(4) of the Act, nor could he approach the civil court. It is submitted by the respondent that in such cases, a civil court may have a jurisdiction to entertain the case as character as a guarantor itself is denied. My lord, now I request my lords to kindly consider.
It is a case where
Yes, my lord.
the character as a guarantor was put in challenge.
No, that is
Here
not.
is a case where you admit pages 30 to 33 you have admitted now.
No. My case is that, my lord, because of the subsequent variance without my consent, I am discharged. That is the issue before the civil court, my lord.
You decide that.
And
You will protect your interest also.
they have enhanced the credit facility without my consent at the variance, my lord. In such situation, my lord, that para number 53, and it is that too by way of an unregistered document. Earlier one was a registered document, and the subsequent all the documents are unregistered document. And COD has considered all these things, my lord. FSL report has been obtained.
Suppose ಆ enhancement ಇರ್ಲಿದ್ರೆ ಎಷ್ಟು ಬರ್ತಿತ್ತು liability?
My lord, to the extent of 6.5 crores, my lord.
6.5 crores. 6.5 crore ಅವ್ರು ಮಾಡ್ಲಿ,
Yes, my
ಆ
lord.
ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ಇದೆಯಲ್ಲ ಮೇಲೆ ಎಷ್ಟು ಬರ್ತದೆ? 1 crore?
Fact, I given this offer, my lord, last week of hearing, that
now
I
he is saying.
5 crore, which is, my lord, is there admitted. Other interest received, we are accepting this,
My-
guarantee, we
my-
release them.
There hope.
We made a submission before the DRT.
My lord, my lord, my only request is that, my lord, this issue was also considered by this honorable court when the RFA was preferred, my lord. All these contentions were considered. And this honorable court came to a conclusion that, my lord, this question has to be decided whether there is
According
evidence.
to you, the mortgage stands discharged?
Yes, my lord.
No. We
Well,
don't agree with.
My lord, that is the section 133 and 135. If there is a variance and without my consent, if the variance has taken place.
Surety is discharged.
Yes, my lord, surety is discharged.
Discharged.
And that is
But-
what I am contending.
Put the guarantee.
The guarantorship goes, my lord.
Don't agree with that.
And that is what that would be decided by the debt recovery tribunal, which cannot be decided by the debt recovery tribunal. It is only the civil court which is competent to do it, my lord.
But I filed one judgment from the
My lord, my lord,
have.
You want to go away with whole?
No, no, I am
even
not
this
saying.
one.
If the civil court decides that, my lord. If
But
the-
up to, see,
Yes, my lord.
so far as 6.5 crore,
Yes, my lord.
for which according to you,
Yes,
you are the guarantor.
Yes, my lord.
For that, let the proceedings go on. For the remaining,
Yes, my lord.
they will not precipitate the demand.
Against the present petitioner.
Over.
Sorry, my lord, I am repeating my submission.
You can't use the law as an instrument of fraud. There is such a great doctrine. No person shall be allowed to use the law as an instrument of fraud on the creditor.
My lord, I request, my lord, to how the Delhi High Court, division bench of the Delhi High Court has considered the similar situation. Page number 126 of the same compilation.
ಇದು ನೋಡಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನೋ ಹೋಗಿತ್ತ ನೋಡಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್.
ಇಲ್ಲ, ಹೋಗಿಲ್ಲ.
You have seen?
Yes.
Verified. 2015 SEC online, Delhi 6724. Name is Gurdeep Singh. Gurdeep Singh versus Punjab and Sindh Bank. What is? ಏನಾದರೂ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗಿದೆಯಾ? ಬೇರೆ ಹೈಕೋರ್ಟ್ಗಳು what they have commented on this judgment. Which is that paragraph you want us to read?
Yes, my lord. Page number 126, my lord. I request my lords to kindly consider, my lord, the para number 6, where they have considered the Mardia chemicals, my lord. Thereafter, considering the Mardia chemicals, the paragraph which para 51, 53, which I read, my lord, it has been extracted. Then para number 7, my lord. I will read the entire paragraph.
In the present case,
Yes, ma'am.
the suit filed by so and so initially decided the surely
The court held in favor of the petitioner and proceeded to entertain the suit. Further, the proceedings before DRT, DRET, however, continued. In these circumstances, recovery proceedings could not be interdicted. It is also.
One second. ಹಂಗಂದ್ರೇನು? Further, before the DRT and DRT, however, continued.
Yes.
In these circumstances, the recovery proceedings could not be interdicted, stopped.
Yes, ma'am.
ನಿಮಗೇನೆಷ್ಟಿದೆ ಇದು?
ಇಲ್ಲ, ಮುಂದೆ. It is also a matter of record that suit has reached an advanced stage of the proceedings. Issues have been framed and the parties have to lead evidence. In my case, I have already led the evidence. If at this stage bank is allowed to proceed against the property and ultimately the petitioner's plea succeed, he would have been prejudiced irrevocably. As against this, the bank is in possession of the suit property and is also the decree holder to the tune of rupees so and so. If the mortgage transaction is held to be genuine, it would be free to proceed against it.
No, here that question will not arise at all. You
Yes.
have admitted it is genuine.
No.
Yeah, therefore, it is, if you replay this, you will know that. You said you do not dispute the documents from page 30 to 33.
Yes, my submission is that, my lord, I admit that my signature, but subsequent variance, I am discharged from the guarantorship.
So,
yes, my lord.
You concede and admit,
yes, my lord,
that this transaction,
yes, my lord,
to plead variance,
yes, my lord,
you have to admit the first position. That's what Chitti on contract
yes,
says.
my lord, I admit that. If I won't admit that position, my lord, the comparison of signature is also not possible. Yes, my lord. If the mortgage transaction is held to be genuine, it would be free to proceed against it. The proceedings under Article 226 of the Constitution of India are discretionary and me to reach out wherever.
That was a case
Yes,
where
ma'am.
mortgage itself was denied.
No.
There you have
Recovery
advocate.
certificate had been issued in that case. Yes, my lord.
That mortgage itself was in challenge.
And subsequently, recovery certificate was also issued, my lord. At that stage, my lord, the courts have discretion to issue orders ex debito justitia. The Supreme Court in so and so, while considering the provisions of the court, my lord, they have extracted that particular judgment. Therefore, on a balance of the equity, we are of the opinion that the recovery proceedings should not go on till the suit is decided finally by one or the other way. And then at para number 8, my lord, the direction has been issued to the trial court. My lord, within 3 months, my lord, proceedings can be concluded, my lord. My evidence will be closed, my lord. They have to cross-examine. Let them adduce the evidence. Entire investigation has been completed, my lord. Charge sheet, 8 volume of charge sheet has been filed, my lord. How much fraud has been committed? All those things have been explained, my lord.
And
yes,
the petitioner before the Delhi High Court was not a party to the loan at all. Please come to para 2. Read now.
Yes, sorry.
He was not a party to the proceedings at all. Therefore, Delhi High Court had shown he was not a party to those proceedings. You are a very much a party here to the DRT.
Yes, ma'am.
To the DRAT.
Yes, ma'am. Only after being a party, then I came to know about these documents, my lord. Otherwise, I would not have come to know.
This judgment.
Yes, ma'am. It was a surface proceedings, my lord.
Proceeding number 1.
Yes, my lord.
Number 2.
Yes, my lord.
He was not a party to the DRT proceedings at all or those proceedings at all.
My lord, it is a surface proceedings, my lord.
He was not a party to those proceedings at all.
Yes, ma'am.
That is one of the factors.
How
are you going to derive the ratio decidendi of a judgment?
My lord,
look into
yes,
what all entered in the making of that norm or legal ratio. One of the factors is
yes, ma'am.
He was not a party to the surface proceedings at all. Therefore, court made that makes all the difference. Your case is firstly that is not under this act, though we can bring some similarity, we can understand.
Yes, ma'am.
But you were a party to those proceedings.
Only after being a party, my lord, I came to know.
Correct.
If I were not the party, my lord.
You came to know of what? Variance.
Yes, my lord. Variance.
Or
yes, my lord.
If you prove that before the court,
yes, my lord,
you will be protected. Why this should be halted?
But before the DRT also, my lord, he can demonstrate, my lord. In fact, DRT, my lord,
my evidence itself has been closed, my lord. I am not permitted to cross-examine also.
This point
DRT cross-examine ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಿರಾ?
ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ. There is, my lord, what had happened, my lord, we filed a OA. They appeared.
ಅಲ್ಲಿ fraud and ಇದನ್ನ ತಗೊಂಡಿದ್ರಾ?
We have taken, my lord.
The contention ತೋರಿಸಿ. Show the contention. What was the stand on which you resisted the recovery proceedings?
Page number 75 in their appeal petition.
All debtors become very, very wise in law and life.
No, my lord, I am a guarantor, my lord. I have saw.
Makes no difference in law.
Para 14 onwards.
Read 86 Supreme Court of Justice C.S. Venkatramaya.
Yes, ma'am.
The guarantor is the pampered party for the lenders. He is worse than the principal borrower.
My lord, I request my lords to kindly take, my lord, para number 17, my lord, page number 79. How the fraud has been played by so many people.
In
DRT,
how you have taken up that content?
Yes, my lord. Para number 17 onwards, I have explained, my lord. The filing of the page number 79, my lord.
Para 14.
No, para number 17. 17, I will start.
This was the objection which you had filed before in the DRT.
Yes, my lord. Yes, my lord.
How you
In para number 17, my lord, the news item which was published with respect of the principal borrower, my lord, when a blue corner notice was issued against him, all those things have been explained in para 17, my lord. Para number.
Have you denied execution of the mortgage deed? No.
Para 14
No, I have. I have to.
Where have you about what you have said about that?
Yes, my lord. Para 14, my lord. Para 14, I admit, my lord, I have executed that particular title deed because otherwise the comparison itself will not take place. And I am on the variance, my lord. Enhancement. Fraud, subsequently it has been fled. And this particular bank, my lord, after its para 15, my lord, where there is a material alteration, I have taken, my lord, the contention in para number 15.
15.
Yes, my lord. Page number 79. That is in the light of section 133 and 135 of the Indian Contract Act, which discharged me from all the guarantorship. And this question, my submission is that, my lord, the civil court has to consider it.
Letter dated 9/8/2012 is fabricated, concocted and concealed document.
Yes, my lord. Which has been referred to, relied upon by my learned friend, my lord.
How these issues are framed? What were the issues framed in the DRT?
DRT, my lord, it's a summary proceedings. Issue, I'll just point, my lord, only one.
ನಮ್ಮ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಟ್ರೆ ಆ ಪ್ರಕಾರ ನಡೆಸ್ತೇವೆ. ನಿಮ್ ಪ್ರಕಾರ ಮಾಡಕ್ ಬರಲ್ಲ. ನಾವ್ ಹೇಳ್ದಂಗೆ ಕೇಳ್ಬೇಕು. ಅವಾಗ ಜಸ್ಟಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ. ನೀವ್ ಹೇಳ್ದಂಗೆ ಕೇಳಿದ್ರೆ ಒಂದ್ ಸೈಡ್ ಆಗ್ತದೆ ಎಲ್ಲ. ನೀವು ಹೇಳ್ದಂಗೆ ಕೇಳಕ್ ಆಗ್ತದೆ. ಆಮೇಲೆ ನಾವು ಮಾಡೋದು ಹೆಂಗ್ ಕೆಲಸ. ನಮ್ಮನ್ನ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡ್ಬೇಕು. ನಿಮ್ ತಲೆಯಲ್ಲಿ ಬಂದಂಗೆ ಏನಾರ ಹೇಳ್ಬಿಟ್ರೆ ನಿಮ್ಗೆ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ ಅಷ್ಟೇ. ನಾವು ಹೂ ಅಂತೀವಿ, ನಾಟಕ ಮಾಡ್ತೀವಿ, ಒಳಗೆ ಹೋಗಿ ಬರ್ದು ಹೋಗಿತೀವಿ ಜಜ್ಮೆಂಟ್. ಅವಾಗ ಏನ್ ಮಾಡ್ತೇವೆ?
ಆಗೋದಿಲ್ಲ.
ಅದೆಲ್ಲಿದೆ ಜಜ್ಮೆಂಟ್? DRT ಜಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ಇಶ್ಯೂ ಅಂತ ಇಟ್ಸ್ ಸಮ್ಮರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ಮೈ ಲಾರ್ಡ್.
ಅದೆಲ್ಲಿದೆ ಜಜ್ಮೆಂಟ್? ಎಲ್ಲಿದೆ?
ಯಾವುದು?
DRT ಆರ್ಡರ್ ತೋರಿಸಿ.
DRT ಅಲ್ಲಿ, ಮೈ ಲಾರ್ಡ್, annexure A, ಲಾರ್ಡ್, ಏನಾಗಿದೆ? DRT ಫೈನಲ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಸೊ ವಾಟ್ ಹ್ಯಾಡ್ ಹ್ಯಾಪನ್, ಮೈ ಲಾರ್ಡ್? Matrix completed our evidence
before the DRT.
Before the DRT, they filed on IA in the OA number, my lord, my lord, kindly come to my lord, page number 27.
IA for
my lord, stay the proceedings in view of the DRT, in view of the
suit
is pending. But I just point out two aspects. My lord, what had happened, my lord, 2015 I filed a OA. Simultaneously, my lord, I also initiated Surface Act in, my lord, in view of transcore, my lord, said
ಇದೇ issues ಅನ್ನ
yes, my lord,
DRT ಮುಂದೆನೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಲ್ಲ. ಅಲ್ಲೇ
whether the DRT is a civil court, my lord, that issue has been decided, my lord, and that has been this court also has considered this issue. One of their contention is that all these questions can be decided by the DRT, but this court come to a conclusion that DRT cannot decide these issues because DRT it is a trappings of the court, but it is only a tribunal, it is not a civil court. It is only a civil court which can decide. There is a definite finding by this honorable court, my lord, in between the same party.
That is in respect of,
and it has attained finality also.
Just 1 minute. We filed a OA in the year of 2015, and we also initiated action under Surface Act. My lord, in view of the transfer, I can do both parallelly. My lord, in the year of 2019 or 18, when we taken a section 14 order, that is, my lord, assailed before, my lord, before that they filed return statement and they're contesting the OA before the DRT. Subsequent to, my lord, I obtained this order under section 40. They filed OS before the civil court, and my lord, my surface measure has been assailed, saying that guarantee and etc. DRT initially civil court granted an interim order. Later, my lord, we appeared, said that, my lord, order 7 rule 11 reduced section 30, we said that they have to go to DRT. Civil court accepted our argument and, my lord, dismissed the matter. They approached this honorable court in RFA. They said there's some fraud. That this honorable court said, my lord, kindly see, my lord, we filed an application under order 7 rule 11 reduced section 34 of Surface Act. It is nothing to do with the RDB. If the RDB had challenged, my lord, I would have filed in section 20. I would have said section 20 is a bar, not 34. 34 is only in Surface. Therefore, my lord, that rightly, my lord, court immediate below, my lord, said that I don't have jurisdiction, you have to go to DRT. This honorable court said that no, it's a fraud is involved. In case fraud is involved, then my lord don't have power to DRT in view of the Mandia, you have to go to my lord civil court. That is in respect of surfacing. My lord, I'll just point out apart from that one issue. When I filed a suit in the 2015, they filed a written statement immediate, my lord, they added as a defendant number 9 before the DRT and they filed a written statement. And my lord, we have my lord, in respect of surfacing, my lord, what will happen? Bank will do everything. 13 I'll issue, 13 I'll issue, and my lord, everything, my lord, only bank will issue only in section 17 where is few scope before the DRT. But in respect of the OA, my lord, it is not bank action. We filed a claim before the DRT under section 19. I have to educate, my lord, summons will go to the borrower. Borrower will appear and they will file a written statement. Borrower and guarantor all. Everybody can take their own contention. DRT may discharge one of the two. My lord, the present petition may discharge by the DRT. DRT may court. DRT is a complete court under section 19. After adducing the evidence, surface is not so. Therefore, my lord, Mardi also, my lord, came to my lord arrest only because of they are not getting an opportunity because of Bank Act. Because 13 and sale notice, rule 86. That is the reason, my lord.
DRT ಏನಾಗಿದೆ ಈಗ?
DRT ಗೆ orders post ಆಗಿದೆ. If my lord directs, my lord, we will, my lord, let them.
ಅವರಿಗೆ ಪರ್ಮಿಟ್ ಮಾಡ್ರಿ ಅವ್ರಿಗೆ ಅದು ಈ ಇಶ್ಯೂ ಮಾಡ್ಲಿ ಅವರು. We will say that DRT will consider.
One submission. I will draw my lord's attention how the court, the question my lords posed to my learned friend, that was the question posed before to the parties.
It was not in relation to DRT.
In relation to DRT only, my lord.
It was surfacey.
No, my lord. That was the contention that it took. The saying that the DRT cannot, whether the DRT can trash out all these issues. Then the one of the submission which was made and which was recorded by this honorable court, whether debt recovery tribunal cannot be equated with the civil court and no discretionary relief can be granted by the debt recovery tribunal. Whether the debt recovery tribunal
is not a court ಅಂತ ಇಟ್ಕೊಳ್ಳಿ.
Yes, ma'am.
Fraud ಇದನ್ನೆಲ್ಲ ಡಿಸೈಡ್ ಮಾಡಕ್ ಬರಲ್ವಾ?
My lord, the fraud, it can't be, my lord.
How you read the P. Changalavara Naidu?
No, my lord. That is.
Please read. Yes. No ಅಂತ ಹೇಳ್ಬೇಡಿ. ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತೇನೆ ನಿಮ್ಗೆ ತಾಚಿಗೆ.
Sorry.
Read P. Changalavara Naidu.
Yes, my lord.
And Meghamala. What is judgment ಅನ್ನು ಎಡ್ ತೆಗೆದು?
My lord, the
fraud can be if there is a fraud, any court, any authority can decide. It can invalidate the proceedings. That is Meghamala. That is P. Changalavara Naidu.
The question, this court, my lord, if the fraud is the aspect.
Means to say.
Yes, my lord.
The issue of fraud can be adjudged only by the civil court.
No. My submission was that, my lord, whether the debt recovery tribunal, after considering the fraud, can grant the relief in favor of the plaintiff, whether the plaintiff can file a counterclaim or maintain a suit before the DRT was the question.
Question adalla.
Yes, ma'am.
You want to be absolved.
Yes, ma'am. From the liability.
Your liability as a guarantor.
Yes, ma'am.
That is perfectly within the jurisdiction of DRT.
My lord, with my submission, my lord, there are that judgment also. That was considered by this honorable court, my lord.
No, fraud is considered. The Changalavara Naidu is considered.
No, my lord, that judgment has not been.
Yes, Changalavara Naidu says it refers to Lord.
The Satyavati Tandon, my lord, then other judgments have been taken into consideration by this honorable court.
Simply, I am telling you.
Yes, my lord.
DRT is a special tribunal.
Yes, my lord.
All contentions that would discharge the liability of the debtor.
Yes, ma'am.
Are open to be adjudged by the tribunal because of decision of apex court in Dhulabai versus State of MP.
Yes,
AR 1969 Supreme Court page 74 or 78. Justice Udayatullah,
yes,
Honorable Chief Justice Ajit Enwar, he has postulated in these circumstances the tribunal has got power. Kodi, Dhulabai 69 Supreme Court kodi. State or 69 Supreme Court. 68 SCR, 69 AR. 68 Supreme Court, 5-judge bench. Yes. 69 Supreme Court, 68 SCR. 69 Supreme Court, 78 perhaps. Correct, huh? Yes. But we are
Yes, ma'am.
Though very persuasively you are arguing,
Yes, ma'am.
our apprehension is,
Yes, sir.
once such a contention is upheld,
Yes, ma'am.
10,000 cases will be filed
understand, I
before the in suits,
Yes, ma'am.
defeating the very purpose for which DRT is established.
My lord, the Dulabai has been considered in Nahar Industrial Enterprises, my lord,
Correct.
by the Supreme Court, my lord. After considering the Dulabai, my lord, in the Nahar industry, the court has come to a conclusion with reference to the jurisdiction of the Debt Recovery Tribunal, my lord.
Holding,
With respect of these type of proceedings, the Supreme Court has come to
which is that judgment?
page number 55 of my compilation, my lord. Nahar Industrial Enterprises, 2009 8 SCC 646, my lord. The Dulabai has been taken into consideration, my lord.
Page number
Page number 55, my lord.
55.
Yes, ma'am. Then, my lord, at para number 67, under the head, whether tribunal is a civil court, the discussion starts.
No, we are not on
Yes.
that. Suppose
Yes.
High Court tribunal is
Yes.
administrative tribunal.
Yes.
It is not a civil court.
Yes.
Every day, in and day out, they dismiss cases because of fraud and fabrication.
Yes. Then, my lord, the court, with reference to section 34 of the specific relief act, whether I can seek for a declaration with reference to these documents as well as guarantorship before the debt recovery tribunal was considered by this honorable court. Correct. Yes.
Your other friends may go for a small round for 10-15 minutes. It will take.
Para 85 would be relevant, my lord. 85, my lord. Page number 98, my lord. If my lords permit, I will read it, my lord.
Yes.
Para 85, my lord.
If the
If the tribunal was to be treated to be a civil court, the debtor or even a third party.
No, we
must be-
fully agree. It is not a civil court at all. It's a tribunal.
Yes, sir. Now, my lord, in the light of that, my lord, I cannot seek a declaration with reference to the documents which my learned friend is referring to as a not binding on me. It is a null and void. And that relief only civil court can grant. That aspect has been considered by this single judge, my lord, at in the interstate dispute between us, my lord. And Nahar has been extracted also. And this honorable court, after considering the Nahar industries, my lord, has held that civil suit is maintainable. And the rejection cannot be sought by the defendant bank.
Two aspects.
Yes, ma'am.
Whether tribunal is a civil court, answer is simple. First year law student would say
yes,
it is tribunal.
Yes.
Therefore, not a civil court.
Yes.
Question is not that.
Yes.
Whether the exclusive tribunal created under a special act.
Yes, ma'am.
Because of Dulabai.
Yes, ma'am.
Will have powers of the civil court.
Yes, ma'am.
for effectuating the purpose of the statute under which they are created.
Yes.
That is the question.
Yes.
Yeah.
If I have made out a case, my lord, if I have made out a case, and only, my lord, with reference to this, my lord, how this court has considered, my lord, Nahar industry, I may be permitted to read the judgment. My lord, the petition compilation, my lord, page number 140, my lord.
Idrali, the Naharnali,
Yes, my lord.
what the apex court said, let us see.
Yes, my lord.
Postulates ಎಲ್ಲ ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ?
Yes, my lord. Page number 73, my lord. Page number 73, para
Not
number.
one bunny, conclusion.
Yes, ma'am.
Page 101, para 96.
Yes. Yes, ma'am. Para 96, the conclusion starts, my lord. Last line, my lord, if my page number 102.
No independent proceedings can be initiated before it by a debtor.
Yes, ma'am.
Ada?
Yes, ma'am.
ಏನು ಅದರಿಂದ
tribunal therefore would not be a civil court. That is one line statement, my lord. Para number 98 would be relevant, my lord. I may be.
Even in respect of set off and
Yes,
counter claim.
Yes, ma'am.
Read.
Yes, ma'am. Para 98 A to L, my lord.
A to L.
Yes, my lord.
Correct.
Yes, my lord. They have extracted, my lord. They have discussed what are the provisions in the act, and then they have said that these are the powers which are available, and it is a summary proceedings, and therefore the tribunal is not a civil court.
Come to N.
Yes, ma'am.
Read.
Yes, ma'am.
It is not, tribunal is not bound by.
It is not bound by procedure laid down under the code. It may, however, be noticed in this regard that just because the tribunal is not bound by the code, it does not mean that it would not have jurisdiction to exercise powers of
a court
as contained in the code.
Code.
Rather, the tribunal can travel beyond the code.
Beyond the code.
Yes, ma'am. And the only fetter that is put on its power is to
observe the principles of natural justice. So not only it has got civil court's power, it has more power. It can transcend the code and do certain things.
Yes, ma'am.
Why are you saying? Because it's a tribunal.
Yes, ma'am.
Whether a tribunal is a court, that question will not raise because it's a tribunal.
Yes, ma'am. Only issue is that, my lord, the issue what I have raised, the prayer what I have sought, whether that can be decided in the debt recovery tribunal in a summary proceedings. Because it has no power under section 34 to declare that these documents are not binding on me. It is a document-wide documents. That relief can be granted. I can only seek before the civil court, my lord. Because it can, at J, my lord, para number 98J, it can only issue a recovery certificate. It cannot pass a decree. In paras 98J, my lord.
That's true. Decree can be passed ordinarily only by the court established under the CPs.
Yes, ma'am.
Or the statute, if authorizes, for example, Waqf tribunal.
And
can pass
land
the
grabbing
decree.
court, land grabbing.
Land tribunal.
Yes,
they can grant decree.
because under section 9.
Because they are
yes,
so enabled.
Yes. Here, the DRT is not enabled, my lord. And I have to seek permission for the cross-examination. And if I won't cross-examine, my lord, it is very difficult for me to prove my case.
No, that would fall in N.
Yes, ma'am. Yes, ma'am. Even cross-examination
Cross-examination.
need not be found to be necessary.
If it is not found to be necessary,
Yes, ma'am.
even court, civil court can say, no need to cross-examine. Question is necessity.
Yes. Para 118, my lord, then there is a discussion regarding section 9 of the code, my lord, in the same judgment, para number 118, my lord, page number 108.
No, our
Posting of the
comprehension is,
jurisdiction. Yes, ma'am.
if in one case, if we hold that way,
Yes, ma'am. Yes, ma'am.
thousands of cases will go before the civil court. Everybody will say, this document of security is obtained by playing fraud, forgery, fabrication.
My lord,
Then, what about?
yes, my lord, I understand the apprehension of the court. I will try to explain, my lord, my situation. My lord, if I have laid the foundation for such type of a situation, I came to know when the news item was published, my lord. But I was not aware what are the documents created. Only when the debt recovery tribunal compilation which reached to me, application compilation reached to me, then I came to know that my signature has been fabricated. Then, my lord, I lodged the complaint. Then so many people lodged the complaint. The borrower has run away from India. A blue corner notice has been issued. Then, my lord, investigation was made by the COD, my lord. They have laid the charge sheet. These are the various
Principal borrower ಏನೇನಿದೆ property?
Oh, he has defrauded many of us like this, my lord, and he has left the country, my lord.
He has gone abroad.
Yes, my lord. He's not. He's in. I'm told that he's settled in Dubai. And he files a written statement before the civil court, my lord. Borrower disputing my submission, and there is no verifying affidavit. Because he has to depose to that verifying affidavit. And I have sought for the rejection of that particular, I have sought striking of that particular written statement. And now the matter has been proceeded for the evidence. I'm in such a precarious condition, my lord. The banker has a duty to me also. I am a guarantor. If the duty is not performed by them, if they have not discharged diligently, my lord, in such cases, my lord, I am entitled to approach the civil court. And my submission is that, my lord, there are sufficient documents to show that, my lord, fraud has been committed.
Fraud, what is that fraud?
The creation of the document.
Which document?
The letter of guarantee document, subsequent enhancement documents, and there are so many documents are there, my lord. All those documents are the basis for them to seek for the recovery certificate. If those documents are the basis to issue the recovery certificate, my lord, definitely, my lord, where I cannot where I cannot claim any relief, I cannot conduct a cross-examination, I cannot extensively adduce evidence also. And if I require to prefer an appeal also against the order, my lord, I am supposed to deposit a huge amount, 50% of the total decretal amount. And my submission is that, my lord, at least 3 months time may be granted, my lord. And by that time, my lord, let these proceedings be kept pending. If I lose, my lord, definitely I'm going to lose the property.
Section 19, for a moment, my lord. My lord, where I filed an application before the DRT under section 19 before the DRT.
Others need not wait, come afternoon.
My lord, we have also filed compilation judgment. I wanted to, my lord, point out before this Honorable Supreme Court, my lord, very clearly said that, my lord, when the DRT proceedings, when OS proceedings, my lord, in the VCK transport, my lord, which I filed before, I'll just point out in that aspect. My lord, first and foremost, my lord, when I filed an application under section 19, my lord, kindly see the power vested with the DRT, my lord. My lord, kindly come to, my lord, 19(4) onwards. They can file
how court has interpreted them, those powers is the question, not section.
Allah. My lord,
Law is what courts say it to be.
DRT have a ample
which,
of power to discharge them. In fact, Monday I argued on matter, wherein guarantor has been discharged because we are not able to made out a case with the DRT against a guarantor. DRT discharge them. The moment DRT discharge, I have to accept handing over the documents. I don't have option. It is also the case, they would have pointed before the DRT saying that fraud taken place. DRT have all the post, they can file a counterclaim. Kindly come to 19.4. They can file a written statement. They can file a counterclaim. DRT will examine and pass an order. In many cases, day-to-day basis, DRT will discharge guarantors. Apart from that, before that, I just point out one judgment from the Honorable FX Court. The very same point considered.
Bank of Rajasthan. With what he says, see, if fraud, fabrication, etc. contention is taken up, that cannot be adjudged by the DRT.
That being the case, my lord, DRT will discharge the guarantor.
Where is the ruling?
Kindly come to the 9 authorities I placed before this honorable court with 3 compilation judgment. First, my lord, I filed it on 1/7/2024. There are list of authorities I placed. My lord, issue 1/7/2024, my lord, the compilation of judgment which I filed. There are 3 judgments I relied. One is my lord Transco, that is my lord DRT and Surface.
Transcore.
Second one is my lord Electricity Casting Limited.
Transcore bani.
Transcore. Transcore, my lord, page start from page number 1. My lord, para 38 is relevant.
38.
36 in the one. In the light of the above discussion, we now examine doctrine of election. There are 3 elements of election. 38, 39, 40. Page number 23 and 24. 22, 23, 24.
Question still. In the light of above discussion, we now examine the doctrine of election. There are clear.
38 DRT can simultaneously go with Surface as well as my lord under section 19. 39 is relevant, my lord. Object behind introducing the first proviso and the third proviso to section 19(1) of the DRT Act is align the provisions of DRT Act, NP Act, that is Surface Act, and Order 22 CPC. Let us assume for a sake of argument that an OA is filed in DRT for recovery of an amount on the term loan, on the credit facility and hypothecation account. After filing OA on account of non-disposal of the OA by the tribunal due to heavy backlog, the bank finds that one of the 3 accounts has become substandard loss. In such cases, the bank can invoke NPA, that is Surface Act, without permission of the DRT. DRT given the honorable.
Next.
In next para.
One cannot lose sight of the fact that.
Please no fact of that. Even an application of withdrawal leave taken time for its disposal, as stated above, with inflation in the economy, value of the pledged property, asset depreciate on the day-to-day basis. If the borrower does not provide additional asset and the value of the asset pledged keeps on the falling, that to that extent of the account becomes non-performing. Therefore, the bank stroke financial institution is required to move under NPA Act, that is Surface, expeditiously, taking one of the measures by section 13(4) of the NPA Act. Moreover, Order 23 CPC, an exemption to the common law principle non-suit, hence the provision of section 19(1) become a necessity.
Scope of 19, jurisdiction of the tribunal, discuss agide.
The act, act Act 19, 1907. 1906 in the defendants where what are the things they can take? 1905 also, my lord.
If the
defendant shall within 30 days from the date of service of summons present a written statement of his defense, including claim set off under section 6 of the counterclaim under subsection 8, if any. Such written statement shall be accompanied with the original documents or true copies thereof, with a leave of the tribunal relied by the defendants in his defense, provided that the defendant files with the written statement within so and so that accept, my lord. Then, my lord, 5B. where the defendant.
Set off and counterclaim both are permissible.
Permissible. But 5B, where the defendants make an admission of a full or part of the amount. In this case, my lord, the part first mortgage and execution of documents is admitted before the DRT as well as before the honorable court. The debt due to the bank or financial institution, the tribunal shall order the defendant to pay the amount to the extent of admission within a period of 30 days from the date of such order, filing with the tribunal which may certificate or record the provisions of this subsection 22 of the extent of the amount of debt due to admitted by the defendant. Where the defendant claims set off against the applicant, demand any ascertained sum of money legally recovered by him from such applicant, the defendant may at the first hearing the application but not afterwards unless permitted by the tribunal present written statement containing the particulars in the set off along with the original documents so and so. And 7, that written statement shall have the same effect as a plaintiff cross suit so as to enable the tribunal to pass final order in respect of both the original claim and set off. 8, a defendant and an application may, in addition to the right of pleadings of set off under section 6, set up by a way of counterclaim against the claim of the applicant any right claim in respect of the cause of acting accruing to the defendant against the applicant either before or after filing of the application, but before the defendant has delivered his defense honor before time limited delivering his defense has expired with whether the counterclaim is the nature of the claim or damage or not. DRT, my lord, they would have filed the either, my lord.
ಈ ಸೆಕ್ಷನ್ ಅನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ?
My lord,
Which judgment considered these
one judgment I just pointed out, my lord, by the Supreme Court, Honorable Supreme Court. The second judgment which I relied, my lord, electrosteel, it starts from 31. It says that, my lord, what is fraud and collusion?
ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರ ಬಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಲ್ಲ.
ಅದ್ರ ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಬ್ಯಾಂಕ್ ಹ್ಯಾವ್ ಎ ಪವರ್ ಟು ಇನಿಷಿಯೇಟ್ ಬೋತ್.
ಅಷ್ಟೇ, ಅದು ಹಂಗಾಗಿ ಅದು ಆ ಪಾಯಿಂಟ್ ಅಲ್ಲ ಇದು.
The second judgment which I relied, my lord, in the case of electrosteel, in the Honorable Supreme Court says that, my lord, para 33 to 36 is relevant. What is fraud? My lord, my senior is keep on harping fraud. Lord, kindly come to my lord in that judgment starts from 31 to 37.
31 to
37. Judgment starts from 31. What is fraud? The Honorable Affix.
ಕುತ್ಕೊಳ್ಳಿ ದೇಶಪಾಂಡೆ, ಕುತ್ಕೊಳ್ಳಿ, I'll come to you.
My lord, in that, my lord, para 33 onwards, that in the judgment, my lord, every one, my lord, my lord, before my lord, I appeared when GMR is every, my lord, guarantor when my lord account become NPA, there is a common song that, my lord, there is a fraud against the, my lord, principal borrower. My lord, in that context, my lord, the Honorable Affix Court said, what is fraud? My lord, kindly come to para number.
ಅದೇನ್ ಬಿಡಿ, ಫ್ರಾಡ್, ಕೆರ್ರಾನ್ ಫ್ರಾಡ್ ಇವನ್ನೆಲ್ಲ ನೋಡಿ ಆಗಿದೆ.
33 ಇದೆ.
ನಮ್ದು ಅದಲ್ಲ. ಈ ಫ್ರಾಡ್ ಕಂಟೆನ್ಷನ್
33 ಇದೆ ಸ್ವಾಮಿ.
ಅದನ್ನ ಟ್ರೀಟ್ ಮಾಡಬಹುದು ಟ್ರೈಬ್ಯುನಲ್.
ನೋಡಿ ಸ್ವಾಮಿ, ಅಲ್ಲ. Having considered pleading and averments in the suit more particularly, the use word fraud, even considering a case on behalf of the plaintiff, we find that allegation of fraud are made without any particulars and only in view to get out of the bar under section 34 of Surface Act, and by such a clever drafting, plaintiff intends to bring the suit maintainable despite of the bar under section 34 of the Surface Act, which is not permissible at all and which cannot be approved. Even otherwise, it is required to be noted that it is one of the case on behalf of the plaintiff appellant hearing that in view of the approved resolution plan under IBC and thereafter the original corporate debtor being discharged, there shall be not be any debt. So far as the plaintiff appellant hearing the concern and therefore the assignment deed can be said to be fraudulent. Therefore, it cannot be accepted by that itself, and the assignment deed cannot be said to be fraudulent. In any case, whether there shall be legally enforceable debt, so far as the plaintiff appellant hearing is concerned, even after the approved resolution plan against the corporate debtor, still there shall be the liability of the plaintiff and or the assignee can be said to be secured creditor, and whether any amount is due and payable by the plaintiff or all the questions which are required to be dealt with the considered by the DRT in proceedings initiated Surface Act. It is required to be noted that such in the present case, the assignee has already initiated the proceedings under section 13, which can be challenged by the plaintiff appellant, wherein by way of application under section 70 of Surface Act before the DRT on whether so legally available defense which may be available to the it. We are of the firm opinion that the suit filed by the dependent appellant wherein was absolutely not maintained in view of the contents of section 34. My lord, the next judgment which I am relying, my lord, it's a very important judgment at the very same point, my lord, dealt from my lord, page number 38. This in the case of my lord, Bank of Rajasthan. I'm so sorry.
in any case, whether there shall be legally enforceable debt as far as plaintiff appellant hearing is concerned, even after the appeal which is there in status, still there shall be the liability of the plaintiff. And can be said to be secure, whether any amount is due, payable, whether all questions which are required to be dealt with, considered by the proceedings initiated under this Surface Act. So the present case. Absolutely not maintainable. Surface. What is
My lord, the next authority would like to rely, my lord, from page number 38 in a very similar facts before the Honorable Supreme Court. Original suit and, my lord, the matter pending for the DRT. My lord, head note itself, my lord, page number 38, para 2. The jurisdiction of the civil court to try the suit filed by a borrower against a bank or finance institution held is not ousted by virtue of the scheme of RDB Act in relation to the proceedings of recovery of debt by the bank or finance institution. However, the proceedings under the RDB Act will not impeded in any manner by filing a separate suit before the civil court by the borrower.
43 to 46.
43 in the same. 43 in the we must note at the threshold itself that.
One niche.
Page number 64.
64.
To the point. We must note at the threshold itself that there are no restrictions on the power of a civil court under section 9 of CP code unless expressly or impliedly excluded. This was also reiterated in the constitution bench of this court in Dular versus so and so, my lord. Thus, it is in the context of the aforesaid proposition that we will have to analyze the rival contention of the parties set out above. Our line of thinking also influenced by 3-judge bench in this so and so judgment, where it was opined that section 9 of the code confers jurisdiction upon civil code determine all dispute civil nature unless the same is barred under the statute either express or necessary implication, and such a bar is not to be readily interfered. The provisions of seeking bar jurisdiction of civil court requires strict interpretation, and court would normally lean in favor of the constitution, the construction, which would uphold the jurisdiction of the civil court. Next 44, it's a very important, my lord. Now, if we turn to objective of the RDB Act, read with scheme and provisions thereof, it is abundantly clear that summary remedy is provided in respect of the claims of the bank and finance institution, so that recovery of the same may not be impeded by the elaborate procedure of the code. Thus, section 6 and 8 of section 19 of RDB Act, that application which is pending. In case of pending proceedings to be transferred to DRT, section 31 of RDB Act to care the issue of mere transfer of the bank's claim, albeit without transfer of the counterclaim. Thus, if the debtor decides to issue a counterclaim, that can be filed before DRT and will be tried along with the case. However, it is subject to caveat that bank may move the segregation of that counterclaim to be relegated to proceedings before the civil court under section 1911 of the RDB Act, though such determination is to take place along with the determination of the claim for recovery of debt. 45. We are thus in the view that there is no provision in the RDB Act by which the remedy is a civil suit by a defendant in a claim by the bank is ousted. But it is a matter of choice of the defendant. Such defendant may file a counterclaim or may be desirous to availing of this more strenuous procedures established under the code, and that is choose whether he takes with the consequences thereof. My lord, then 53. I'll just skip, my lord, 46 to my lord, 52, 53. We certainly would not like that the process invest under the RDB Act be impeded in any manner by filing a separate suit if a defendant chooses to do so. A claim petition before the DRT has to proceed in a particular manner and would so proceeded, there can be no question of stay. Those proceedings by way of civil proceedings instituted defendant before the civil court. The suit would be take its course while petition before the DRT would take its own course. We appreciate that this may be in the nature of parallel proceedings, but then it is defendant's own option. We see no problem with the same as long as the objective of the having expeditious disposal of the claim before the DRT under the ADB Act is not impeded by filing a civil suit. Thus, it is not open to defendant who may have taken recourse to the civil court to seek a stay on the decision DRT awaiting the verdict of this suit before the civil court, as it is matter of the choice. My lord, next parameter, my lord, Honorable FX Court said, my lord, the DRT has. Now, my lord, there are one more compilation which I filed. Next, on file it on 20, one more is there, 25. 25. No, 23. My lord, I filed it on, my lord, 2311. There are 3 compilation of judgment which I filed.
One sentence allere, even claims relating to fraud, fabrication
not
can be adjudged by the tribunal. One sentence allere suggestion is
My lord, Bank of Rajasthan, the question of fraud was not at all there.
was not.
No, that was not a subject matter.
If I relied, my lord, not in the context of DRT, my lord, I'll just point out, my lord, that one judgment before this honorable court. That the 3rd compilation of judgment which I filed, my lord, Reliance Salt, Own Banda, Reliance Salt. My lord, in this case, my lord, bank guarantee was, my lord, questioned before the honorable FX court. Compilation filed it on, my lord, 25 November 2024.
23 November.
ಹೌದು ಸ್ವಾಮಿ 25 ನವೆಂಬರ್ ಹಾಕಿದೆ
25 ಇನ್ನೊಂದಿದೆಯಾ?
ಹೌದು 3 ಅಥಾರಿಟಿ 3 ಕಂಪ್ಲೇಷನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ ಇದರಲ್ಲಿ ಹೌದು ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವುದು ಇದೆ ಅಲ್ವಾ ರಿಲಯನ್ಸ್ ಸಾಲ್ಟ್ Reliance Salt is the first judgment. Reliance Salt in that compilation judgment filed it on 25 November 2024. November. The first judgment by the Honorable Supreme Court in the case of Reliance Salt versus Cosmos Enterprises. The bank guarantee was the issue, my lord. I'll draw my lord's attention to my lord.
Bank guarantee ನಮಗೆ ಇಷ್ಟೇ ಅವ್ರು ಹೇಳೋದು.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ?
Fraud fabrication ಇತ್ತು ಅಂದ್ರೆ
this matter, my lord. The Honorable FX Court said, even when you are admitting the first liability, remaining liability may fraud or any in the, my lord, if he succeeded, there is a fraud. My lord, in all the, my lord, even though, my lord, he is able to pay my claim in the first, when he is admitted that debt. Here, my lord, I'll just put it in this way. My lord, when that my lord, we have claimed certain claim before the DRT. First loan, enhancement. My lord, he is disputing that enhancement.
ಎರಡು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. ಒಂದು fraud, fabrication, duplicity, number 1. Number 2, the creditor does something in variance with the obligation created by virtue of guarantee. ಯಾವುದು 128 129 ಯಾವ ಸೆಕ್ಷನ್?
133 and 135.
133.
Yes, ma'am.
ಅಲ್ಲಿ whether ಆ ವೇರಿಯನ್ಸ್ ಒರಿಜಿನಲ್ ಲಯಬಿಲಿಟಿನೇ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ತದೆ ಇಲ್ಲ ಅನ್ನೋದ್ರ ಮೇಲೆ ವಾಟ್ ಈಸ್ ದಿ ಲಾ ಆನ್ ದ ಪಾಯಿಂಟ್, ಮಿಸ್ಟರ್ ದೇಶಪಾಂಡೆ?
Yes, my lord. There is one judgment, my lord, a very old judgment, my lord. Muhammad Ali Jinnah has argued. I will place that judgment on record, my lord.
My lord permits, I'll just point.
ಜಸ್ಟ್ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊತೀವಂತೆ. ಸ್ವಲ್ಪ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ ನಿಮ್ಗೆ ಇಲ್ಲ ಅಂತಲ್ಲ, ಬಟ್ ನಮ್ಗೆ ತಪ್ಪು ಲಾ ಲೇ ಡೌನ್ ಮಾಡೋದು ಬೇಡ ಆಗಿದೆ. ನಾಳೆ ಒಂದು 10,000 ಸೂಟ್ ಬರ್ತದೆ ಅದಕ್ಕೆ. ಅದು ಸ್ವಲ್ಪ ನಿಮ್ಗೆ ಫ್ಲೋ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ವಲ್ಪ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ ಇಲ್ಲ ಅಂತಲ್ಲ, ಬಟ್ ಜಸ್ಟ್ ಆಲ್ರೈಟ್ ಫಾರ್ ಅವರ್ ಪರ್ಪಸ್.
Sorry, my lord. I have only one copy, my lord.
ಏನದು?
That is Privy Council judgment, my lord.
Saying?
Straight, he will be discharged, my lord. In considering section 133 and 135 of the
entire
yes, ma'am. Yes, ma'am.
ಏನು ಓದಿ?
Sorry, my lord. I have
ಓದಿ.
Yes, ma'am.
ಯಾಕೆ ಲೌಡ್ಲಿ ಓದಬೇಕು ಅಂದ್ರೆ
Yes, ma'am.
ತುಂಬಾ ಜನ ಯಂಗ್ಸ್ಟರ್ಸ್ ಬರ್ತಾರೆ ಕೋರ್ಟಿಗೆ, ಏನೋ ತಿಳ್ಕೊಳ್ಳೋದಿರ್ತದೆ.
Yes, ma'am.
ಆಮೇಲೆ ಎಲ್ಡರ್ಸ್ಗೂ ಬೇಕಾಗ್ಬೋದು. ಎಲ್ಡರ್ಸ್ ಲೈಕ್ ಅಸ್, ಅಟ್ ಲೀಸ್ಟ್ ಮೀ, ವಾಂಟ್ ಟು ನೋ. ಕರೆಕ್ಟ್ ಗೊತ್ತಾಗಬೇಕಲ್ಲ ನಮ್ಗೆ ಏನು ಅಂತ. ಲಾ ಕರೆಕ್ಟ್ ಎಲ್ಲ ಗೊತ್ತಿದೆ. ಯಾಕಂದ್ರೆ ನಾವು ಎಲ್ಲೆಲ್ಲಿ ಕೊಡಿಸ್ತಾರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ. ಒಂದ್ ದಿವ್ಸ ಬ್ಯಾಂಕಿಂಗು, ಇನ್ನೊಂದ್ ದಿವ್ಸ ಸರ್ವಿಸ್ ಲಾ, ಟ್ಯಾಕ್ಸೇಷನ್ ಲಾ, 10-16 ಸಬ್ಜೆಕ್ಟ್ಸ್ ಇರುತ್ತೆ. ನಾವು ಎಲ್ಲದನ್ನೂ ಮಾಡಲೇಬೇಕು. ಎ ಸೋಲ್ಜರ್ ಹ್ಯಾಸ್ ನೋ ರೈಟ್ ಟು ಸೇ no, I'll fight battlefield only if it is in South India but not in North India. ಹಂಗೆ ಹೇಳಕ್ ಬರ್ತದೆ. ಯಾವ ಕೇಸ್ ಕೊಡ್ತಾರೆ ಅದನ್ನು ಡಿಸೈಡ್ ಮಾಡಬೇಕು, ಹಾಕ್ಬೇಕು.
Lord, I will, the finding which is,
ಸಿಂಗಲ್ ವರ ಏನಾಯ್ತು ಏನಂತ ಮಾಡ್ತಾರೆ? That is what Mr. Deshpande is saying. If issue of fraud is taken up, fraud fabrication is taken up, tribunal cannot decide on your contention.
yes,
ಅದು ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಇಷ್ಟೆಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ, ಆ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಬೇಕಪ್ಪ ನಮಗೆ. ಹಿಂಗರೇ ಇರ್ಬೇಕು, ಹಂಗರೇ ಇರ್ಬೇಕು. ನಾವು ಎಷ್ಟು ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡಿದ್ರು ಲಾ ಶೋಸ್ ಇಟ್ಸ್ ಫೇಸ್ ಇನ್ ಮಾಸ್ಕ್ ಅಂತ ಹೇಳ್ತಾನಲ್ಲ ಜರ್ಮಿ ಬೆನ್ಥ್ಯಾಮ್, ಹಂಗೆ ಅನಿಸ್ತದೆ. ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಶೋ ದ ರೇಷಿಯೋ ಇನ್ ಮಾಸ್ಕ್ ಆಗಿದೆ ನಮಗೀಗ.
the Privy Council judgment, my lord, copy.
ಅದು ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ಶ್ಯೂರಿಟಿ. ಆನ್ ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ಶ್ಯೂರಿಟಿ ಏನದು?
In the light of section 128, they have decided, my lord, under the Indian Contract
In
Act.
fact, Mr. Jinnah was a great lawyer.
Yes.
Even Mr. M.C. Chagla in Roses in December says about that. He was a great lawyer. But Jinnah ಹೊಗಳ್ತಾ ಇದೆ ನಾವು anti national ಅಂತ ಎಲ್ಲ ಹೇಳ್ಕೊತ ಅಡ್ಡಾಡ್ಬೇಡ್ರಿ. We are only saying ಈಗ ಅನೇಕ ಜನ ಬಾಂಬ್ ಮಾಡಿರ್ತಾರಪ್ಪ, ಬಹಳ ಉತ್ಕೃಷ್ಟವಾದ ಬಾಂಬ್ ಅನ್ನು ತಯಾರಿ ಮಾಡಿದ್ದಾನೆ ಅಂತ ನಾವು ಹೇಳಿದ್ರೆ ನಾವು ಬಾಂಬ್ ಮೇಕರಿಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತಲ್ಲ. ಇದೊಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಈ ಕಿವೇಟ್ ಎಲ್ಲ ನಾವ್ ಯಾಕೆ ಎಂಟರ್ ಆಗ್ಬೇಕಾಗಿದೆ ಅಂದ್ರೆ ವಿ ಆರ್ ಆನ್ಲೈನ್ ಅನ್ನೋದಕ್ಕೆ ಈ ಕಿವೇಟ್ ಬೇಕಾಗಿದೆ.
Yes, my lord.
ಯಾವ ಪೇರ ಅದು?
Yes, my lord. There is no paragraph, my lord. Page number 215, my lord.
215.
Yes, my lord. But the last but one paragraph I will start, my lord. In their lordship's opinion, the surety
Sureties cannot be held liable in respect of this performance, which was not what they contracted to guarantee.
It appears to their lordship that
the law on the discharge of surety has been somewhat obscured by the emphasis laid in the cases of agreement between the parties to vary the terms of original agreement. The principle is that the surety, like any other contracting party, cannot be held bound to something for which he has not contracted. If the original parties have expressly agreed to vary the terms of the original agreement, signs questioner, the original contract has gone, and unless the surety has assented to the new term, there is nothing to which he can be bound, for the final obligation of the principal debtor will be something different from the obligation which the surety has guaranteed. Presumably, he is discharged forthwith on the contract being altered without his consent, for the parties have made it impossible for the guaranteed performance to take place. ಎಲ್ಲಿದೆ? ನಾ ಹೇಳೋದು ಅರ್ಥ ಆಯ್ತಾ?
yes, ಅರ್ಥ ಆಯ್ತು.
ಆ ಪಾಯಿಂಟ್ ಹೆಂಗೆ ಚಿಟ್ಟಿ ಅವ್ನ ಕಾಂಟ್ರಾಕ್ಟ್
Yes.
ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗೋದು.
Yes,
ಈಗ ಅಪ್ ಟು ಒನ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಯು ಹಾವ್ ಇಟ್, ಅವ್ರು ಹೇಳೋದೇನ್ರಿ, ವಾಟ್ ಎವರ್ ಯು ಹಾವ್ ಅಡ್ಮಿಟೆಡ್
yes, sir.
ದಟ್ ಅಟ್ ಲೀಸ್ಟ್ ಯು ಆರ್ ಬೌಂಡ್ ಬೈ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಏನು ಅದು ಹೋಗ್ಬಿಡ್ತದೆ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
Yes,
ಅದು ಆ ಪ್ರಪೋಸಿಷನ್ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ ಅಂತ. ಚಿಟ್ಟಿ ಆನ್ ಕಾಂಟ್ರಾಕ್ಟ್
yes,
ಅಥವಾ ಚಶೈರ್ ಫಿಫೂಟ್ ಅಂಡ್ ಫರ್ಮ್ಸ್ಟನ್ ಆನ್ ಲಾ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್, ಆನ್ಸನ್ಸ್ ಆನ್ ಲಾ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್, ಅವನ್ನೆಲ್ಲ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. In the next page only.
yes, ma'am.
In
In the vast majority of cases, a different performance of original contract is due to an express variation of the term between the parties, and it is natural that the reported cases should mainly deal with this situation. But it is important that the underlying principle should not be obscured. A good illustration of the essential rule is afforded by the case of Blessed versus Brown. In that case, the surety had guaranteed the payment by a banker to the flour merchant for flour to be delivered to the banker for the purpose of baking bread that he supplied for army requirements. The flour was to be of specified quality. The merchant delivered flour which was not of that contract description. The surety commenced a suit in chancery to have it declared that the surety bond was void in equity by reason of misrepresentation and by reason of the conduct of the parties. After dealing with the case based upon the misrepresentation, the Lord Chancellor so-and-so proceeded as follows. It must always be recollected in what manner a surety is bound. You bind him to the letter of his engagement. Beyond the proper interpretation of that engagement, you have no hold upon him. He receives no benefit and no consideration. He is bound, therefore, merely according to the proper meaning and effect of the written engagement that he has entered into. If that written engagement is altered in a single line, no matter whether it be altered for his benefit, no matter whether the alteration be innocently made, he has a right to say the contract is no longer that for which I engaged to be surety. You have to put an end to the contract that I guaranteed, and my obligation therefore is at an end. Now I construe this engagement to be an engagement to be answerable for floor supplied is in conformity with the requisitions of the contract. Then I ask, de facto, was any floor supplied to Miller in conformity with the requisition of the contract? The answer of the defendants themselves is an admission that none such was supplied. The conclusion is plain, therefore, that no legal obligation so far as the surety is concerned arises upon what has been done under this contract, so construed, as I hold it ought to be construed, as is involving the representation that I have stated. A similar application of the principle may be found in Smith versus Wood. There, a number of persons as core sureties had deposited their title deeds with the creditor to secure a debt of the principal debtor. The creditor allowed one of them to create a prior charge in favor of a third person. It was held that though the creditor had not released his charge, yet he had permitted a prior charge to be created, which interfered with the rights of the other co-sureties to have the securities marshaled, and that performance being altered in this way, they were all discharged. It is unnecessary to consider whether the case might not have been treated as one where a security was sacrificed, in which case the surety might only have been discharged to the extent of value of the security lost. Its value for present purpose is that without any agreement between the creditor and the surety to vary the contract, the fact that the creditor stood by and permitted something to be done which made the original performance impossible discharged the other sureties whose consent had not been obtained. In their lordship's opinion, therefore, the sureties are being sued in respect of an obligation which they did not contract to make good and are entitled to succeed. It is perhaps desirable to add that the application of this principle must always depend upon a correct analysis of the contract in fact made.
Correct proposition ಬರಲ್ಲ. ನಿಮಗೆ ಬೇಕಾಗೋ ಪ್ರಪೋಸಿಷನ್ ಎಮರ್ಜ್ ಆಗ್ತಾ ಇದೆ.
Yes.
ಆ ರೀತಿಯಿಂದ.
Yes.
In other words, ಅದು ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ವೇರಿಯನ್ಸ್ ಇದೆಯಲ್ಲ, ಅದು ವೇರಿಯನ್ಸ್ ಆಫ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಟು ವಿಚ್ ದೇ ಆರ್ ಪಾರ್ಟೀಸ್. Because when I contract, I barter away certain my liberties, my property, my money, something I give up. Ali. Adu guarantee ಕೊಡ್ತಾ ನಾವು. A, B, C being the guarantor. Surety. Suppose ಈ ಅರೇಂಜ್ಮೆಂಟ್ ಅನ್ನೇ ನೀವು ವೇರಿ ಮಾಡಿದ್ರೆ ಅವಾಗ ಯು ಆರ್ ಡಿಸ್ಚಾರ್ಜ್. ಅದನ್ನ ಬಿಟ್ಕೊಂಡು ಬೇರೆ ವೇರಿ ಮಾಡಿದ್ರೆ, as Banks Council says, to that extent you continue to be liable, but others you may argue that you are not liable, you are discharged.
Original arrangement was for the extent of 7.5 crores, my lord.
Correct.
Then without my consent, there is an increase in my liability.
Correct.
So original,
arguably.
Yes, madam.
Yes. We are ready to make some more research on this.
Yes, ma'am.
ನೀವು ಮಾಡ್ಕೊಂಬನ್ನಿ.
Yes, ma'am.
ಇಷ್ಟೇ ಪಾಯಿಂಟ್.
Yes, ma'am.
ಅಲ್ಲಿ liability,
yes, ma'am.
Discharge of liability because of variance is pro tanto variance.
Yes, ma'am.
Not in absoluto.
Absolving my liability.
ಹಾಗಲ್ಲ ಅನ್ನೋದು ಹಂಗ ಅನಿಸ್ತದೆ.
Yes, ma'am.
But ಅಂತ ಕ್ಲಾರಿಟಿ ಇದರಲ್ಲಿ ಬರ್ತಾ ಇದೆ.
I will also make my
ನೋಡ್ಕೊ.
Yes, ma'am.
He may be right ಅಂತ ಒಂದು ಫೀಲ್ ಇದೆ ನನಗೆ.
Yes, ma'am.
But Lord, I may make one more submission. Now, my lord.
ಆಯ್ತು, ನೋಡೋಣ ಅಂತೀವಿ. ಬೇರೆ ನಮ್ಗೆ ಇನ್ನೂ
ಮತ್ತೆ hearing ನಾಳೆ.
ಏನು ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಇದೆಯಾ?
My lord, I have to recover 80 crore rupees, my lord, as on today. In fact, we have given several opportunities.
Next week, my lord. ನಾವು ಓದ್ಕೊ ಬರ್ತೇವೆ.
Before debt recovery tribunal, it is on 19th of February, my lord.
No,
why submission is that We will argue the matter and we will assist the court for that.
ನಮ್ಮ ಇವ್ರು ಗೊತ್ತಿಲ್ಲ ನನಗ್ ಕಾಣಂಗ್ ಕೊಡ್ಬೇಕು ಎಲ್ಲಿ ಕೊಡ್ತೀನಿ ಅಲ್ಲಿ ಒಳಗಡೆ ಕೂತ್ಕೊಂಡ್ಬಿಡು ನನಗ್ ಕಾಣ್ಬೇಕು ನೀನು ಅದಕ್ಕೆ ನಿನ್ಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ ಕೋರ್ಟ್
Under the caption for further hearing.
Further hearing.
ಅಷ್ಟೊಂದು ಚೇಂಜ್ ಆಗ್ತಾವ ಅದೇ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
Yes, interim order may be continued.
Interim order continue. ನಾವು ಜಡ್ಜ್ಗಳು ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಹೇಳಿದಾಗನೆ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ಬಾರ್ದು, ರೆಸಿಲಿಯಂಟ್ ಆಗಿರ್ಬೇಕು, ಸೊ ದಟ್ ವಿ ವಾಂಟ್ ಟು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಸಮಥಿಂಗ್ ಮೋರ್ ಫ್ರಮ್ ಯು ಪೀಪಲ್. ಅದಕ್ಕೆ ಏನೋ ಒಂದು ಹೇಳ್ತಿರ್ತೀವಿ. ಏನು ಎಂಡ್ಲೆಸ್ ಲರ್ನಿಂಗ್ ಇದು ಲಾ ಅಂದ್ರೆ. ನನ್ ಕಾಣಂಗ್ ಕೊಡ್ಬೇಕು ನೀನು, ಏನೋ ಕ್ವಶನ್ ಇರ್ತದೆ ಅದನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡು ಅಂತ ಹೇಳ್ತೀನಿ, ಅಡಿಗೆ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನೋ ಅಪರಾಧ ಮಾಡಿ ಅಂತ ಅನ್ಕೊಳೋ ರೀತಿ ನಾವೇನ್ ಮಾಡೋಣ.
please.
67 na?
Manoj, in the
Page 67?
No, Manoj, it will start at page 20 is the Delhi High Court decision, 28 is the Supreme Court.
Twenty 24 ITR,
Please, Manoj,
464 ITR.
yes. 464, passed by Honorable Miss Joint Commission versus Clicks Capital at the bottom of page 28. It starts.
Huh?
My lords, of page 28, Manoj.
28 is Joint Commissioner of Income Tax.
Versus Clicks Capital, Manoj.
Correct.
That is
Clicks
Honorable,
Capital.
Honorable Supreme Court's order.
Correct.
On the following page, page 29, Manoj. Heard the learned counsel at the bottom, Manoj. Heard the learned counsel for the appearing for the petitioner, delay condoned. No case for interference is made out in exercise of our jurisdiction under Article 136. The special lease petition is accordingly dismissed. Pending application also stands disposed of. The High Court order which it affirmed, I have placed it just before that. SLP has been dismissed.
SLP.
Yes, my lord.
But he's heard it, man. Heard the learned counsel. It is not a
Correct.
simple.
No leave is granted.
Please.
ಅವಾಗ ಇದು ಆಗಲ್ಲ, ಅದು ಮರ್ಜ್ ಆಗಲ್ಲ.
Then there are 6 separate orders. My learned friend, if he wants to start, he can start.
Okay. ಅದೆಲ್ಲಿದೆ? ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ.
I'll start, my lords.
ಎಲ್ಲಿದೆ?
No, just before that, my lords, to see what is the issue, my lords. May I just take my lords to the CIT appeal order, my lords, because that is gives the crux of the matter, my lords. Just few paragraphs.
But
because, my lords, I'm not reading the penalty order, my lords.
ಅಲ್ಲ, ನಂಗೆ ಇಷ್ಟೇ ಕೊಡಿ. JCIT ಯಾವತ್ತು ಇನಿಷಿಯೇಟ್ ಮಾಡ್ದ?
Yes, my lord. That is
17.
ನಿಮ್ದು ಪ್ಯಾರಾ 4.
Yes, sir.
So it's told.
10-11.
2017.
10-11.
2017.
JCITಗೆ ಇನ್ನೊಬ್ರು ಯಾರೋ ಒಬ್ರು ಇದ್ದಾರೆ.
Reference ಬಂದಿದ್ದು. The reference to the JCIT.
ಯಾರು ಮಾಡಿದ್ದು?
16 assessing officer.
Assessing officer.
Yes, he's the ITO.
ITO.
Yes.
ITO's reference.
16/11/2016.
Yes, my lord.
Sixteen.
11/2016.
2016 it is.
And penalty order date is 22/2.
2008. Yes, my lords.
Penalty order is made on
22nd February 2018. 22.02.2018.
The question is, my 16/11 a starting point or the 10/11/2017 starting point, my lords? That is the question. Yes, my lords. Lords, I've given a brief note, my lords, highlighting what has happened in this matter and the continuation of the revenue, my lords, in the 5 points, my lords, nothing more than that. My lords, we are dealing with the assessment year 12-13, my lords. What has happened is the assessment order was passed on 2015 February. Now, my lords, what is the income tax office?
ಅದನ್ನ ಓದಿ 271D ಓದಿ.
Yes, my lords.
ಕೊಡಿ. Within what period ಇರಬೇಕದು?
That is, my lords, 275(1)C. I'll just come, my lords, after 271D. The penalty for failure to comply with the provision section 269(SS).
ಎಲ್ಲಿದೆ?
271D, my lords.
271D. Penalty for failure to comply with the provisions of section so and so.
Yes, my lords. If a person takes or accepts any loan or deposit or specified sum in contravention of provision of section 269(SS), he shall be liable to be paid by way of penalty a sum equal to the amount of loan or deposit or any specified sum so taken or accepted. Any penalty imposable under subsection 1 shall be imposed by Joint Commissioner. Subsection 2, my lords.
So it shall be imposed by the
Joint Commissioner.
Commissioner.
Yes, my lords.
ಒಂದು ನಿಮಿಷ. ಇದು power to impose penalty.
Yes, my
The
lord.
power to initiate. The penalty
My lords.
order must be passed by the Joint Commissioner
Joint
above. Anybody can initiate it.
My lords, isn't
That is what has been interpreted. Yes.
Lords, isn't it, my lords, today, my lords, a person imposing penalty should also hear the parties, my lords. Today, my lords, my lords, who does not have jurisdiction, will issue notice, my lords, and some third party will impose penalty.
ಅದು
Just
ಇನ್ನೊಂದು
violate
provision
the
ಯಾವ್ದಿದೆ?
My lords, please look at the procedure, my lords, for imposing penalty.
This only speaks of who is
Joint
the
commissioner.
competent authority.
Yes, my lords. Joint commissioner is a competent authority to issue a penalty.
271
Yes, my lords. He shall impose. Before imposing, my lords, what does he have to do?
And let us
Yes,
see.
my lords. That's 274, my lords.
274. huh?
Procedure.
Page 1.1426.
Yes, my lords.
Right.
Procedure. No order imposing penalty under this chapter shall be made unless the assessee has been heard or has been given
It
reasonable.
speaks of procedure.
Yes, my lords. So, my lords, a person who is imposing penalty, my lords, will have to be heard, and a person, competent authority will also have to be given opportunity, my lords. Now, my lords, no order imposing penalty under this chapter shall be made by the income tax officer where the penalty exceeds 10,000 rupees. B, my lords, by assistant commissioner or deputy commissioner where the penalty exceeds 20,000 rupees, except with the prior approval.
Subsection 1 enacts principles of natural
National
justice.
justice. So, my lords,
Subsection 2
Says
puts
who?
limitations
Yes, my
The
lords.
power to
On-
pass the order,
pecuniary powers.
to pass the order.
Order.
Yes, my lords.
ಎಷ್ಟಿದ್ರೆ ಎಷ್ಟು?
Yes,
ಯಾರು?
my lords. My lords, today, my lord, under 271D, if the joint commissioner has to impose penalty, under 274, my lords, he has to hear the matter, my lords. Because, my lords, if I have to impose penalty,
Correct.
yes, my lords. So
ಅದ್ರ
the,
ಮೇಲೆ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಕ್ವಶನ್ ಅದಲ್ಲ. ಇನಿಷಿಯೇಟ್ ಆಗಿದೆ ಅನ್ಲಿಕ್ಕೆ ಯಾರಿಂದ ನಾವು ನೋಡ್ಬೇಕು?
yes, my lords.
ಅದೆಲ್ಲಿದೆ?
Initiation, my lords, that is where the law is silent, my lords. Please look at 275 1C, my lords, bar of limitation where we have to deal with.
75 1
1C, my lords. 1C.
page ಅಲ್ಲಿ.
Just overleaf of the book, my lords.
You are right.
275, my lords, starts off saying bar of limitation for imposing penalty. No order imposing penalty under this chapter shall be passed because A and B does not apply to our case, my lords. Both parties agree on that. We are on C, my lords. This 275 1, A and B does not apply. C applies for both of us, my lords. We both parties agree on that.
Uh-huh.
So we C read, my lords,
In any other case.
case after the expiry of the financial year in which the proceedings in the course of which action for imposition of penalty has been initiated or completed or 6 months from the end of the month in which action for imposition penalty is initiated, whichever period expires later.
The second limb is relevant. First limb again is not. In 275 1C, because later. So
6 months.
6 months from the end of the month in which the action for imposition of penalty is initiated.
So initiation is spoken of there.
Yes, my lords. Action for initiation, my lords, action for initiation will only commence when the competent authority issues a show cause notice. Not, my lords, when the reference has been made, internal reference.
ಅಲ್ಲ, ಆ initiation should be within such and such period ಅಂತ ಎಲ್ಲಿದೆ?
That's right.
No,
In
ma'am.
fact, that is what again Delhi High Court has said in the later decisions, which say that if there is no time period provided for initiation, what can happen is 5 years later, 6 years later, they can initiate it, but so long as they pass it within 6 months of initiation, it is in time.
So
So
that will be absurd to
that-
the
yes,
assessee.
precisely
So
that
assessee can
reason.
never sleep well.
Yes, that is the precise
So
reason given.
Delhi High Court, my lords, what had happened is factually, there was a 10 years gap, my lords, from the day of initiation and day of imposing, my lords. 10 years, my lords, and that was challenged in writ petition. That was not challenged in IT, income tax tribunal. It was not a substantial question. So on the assumption of
Ah.
jurisdiction, my lords.
Law, law ಅನ್ನಕ್ಕಿಂತ statute is silent
Yes, ma'am.
as to within what period penalty proceeding should be initiated.
Yes, my lords.
Although it loudly speaks about the period within which the penalty proceeding should be accomplished once initiated.
Yes, my lords.
Initiation ಇಲ್ಲ.
Yes, my lords.
In such case, there is one judgment of the apex court, State of Karnataka versus Nekkanti, arising under the PTCL Act.
16 years, my lords, they do it 16. My lords, even for BDA matters, my lords, if within 5 years, my lords, they don't take assumption of the land, then the acquisition will lapse, my lords. So every time a reasonable opportunity or reasonable time is what the law says.
Not that simple. These are all quasi-criminal proceedings,
Yes,
they
my lord.
kind of. Are they so held already? No.
I'm sorry, ma'am.
The penalty proceedings,
Yes.
are they quasi-criminal proceeding?
In
Any
effect, the
judgment?
penal. I'll have to examine that, but in effect, because the penal provisions.
Is,
penal-
will be automatically quasi-criminal.
It's quasi, my lords. It's quasi criminal, my lords, because the penalty will also follow with, my lords, with the imprisonment also. Not for this offense,
Ah.
not for this
Not
offense,
in this,
but for other offenses, my lords.
Other, Income tax act. 3 months. So prosecution ಇದೆ.
Prosecution, my lords, but not for this offense, my lords, not for
Not to this.
unsecured liens.
This is only penalty specific.
Yes, my lords.
Only fine. and,
Fine.
Fine.
Of twice. Yes.
So this is a gray area, my lords. Should the revenue be circumscribed by a limitation period for initiation proceedings or not is a question.
No,
that
where
falls
there
under
is no limitation period,
reasonable
there
time.
is no limitation period, then it is a reasonable period. So in every case, you know, limitation, penalty clause.
468.
468.
468, yes.
Condonation provision. Condonation ಇದೆಯೋ extension of period
ಅದೇ
ಇದೆಯೋ? Extension of limitation period ಇದೆ. ಅಲ್ಲೇ ಬಟ್ ಇದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ.
No, my lords.
ಅಲ್ಲಿ ಇದ್ದಂಗಿಲ್ಲ.
6 months.
Okay.
My lords, may I
Okay.
say this, my lords?
6 months. That is limitation. Yes, correct. Up to 2 years idre 2 years. 2 years and above idre no limitation.
My lords, the reason, my lords, we did some research as to why there is no time limit for initiation, my lords. Because what happens, my lords, most of the time the officers, my lords, assessment officers are not at the level, my lords, of the joint commissioner anyone. So, my lords, they'll have to process the files, everything, my lords. And today, my lords, let's say, my lords, I as an income tax officer censor files for initiation penalty proceedings. The joint commissioner, my lords, may take an independent view not to show cause notice. It can be, my lords, because the joint commissioner, before issuing a show cause notice, my lords, will have to give some sort of reasons or finding saying that there has been a violation of XYZ provisions. So you please reply to that. Otherwise, my show cause notice will be vague. That will be a ground for, my lords, in the writ petition.
ಅಲ್ಲ if
And my lords, I also agree, my lords, as an officer, my lords, if 10 years, my lords, have come and gone by, as what had happened in Delhi High Court, then, my lords, the writ petition will completely lie saying that the officer cannot sit on the file for 10 years and then say, I'll do a penalty proceeding
no,
against you.
ಅದೆಲ್ಲ question ಅಲ್ಲ.
That is what Delhi High Court has said, my lords, which
In
is
one of the
understandable.
other cases, there were 5 days, 6 days, even then the Delhi High Court in appeals. The one decision,
Question
ahead,
ಅದೆಲ್ಲ
the others are all income tax.
Question is simple now. Statute is as clear as it can be.
Yes, my lords.
Clarity is that there is no clarity. In the sense, there is no limitation.
Yes, my lords.
Perhaps on that we have to agree. There is no limitation.
Yes, my lords.
By textual interpretation
yes.
of these provisions.
They provide the end date, not the starting date. But in my case, they have started it. That is the point. They've
No.
started it. When is it started is the question. Is it started when the assessing officer issues the reference? Or is it when the joint commissioner, based on based on the assessing
No,
officer?
that makes no sense at all. As long as statute does not prescribe the limitation for initiation and speaks of accomplishment within the period prescribed, then statute the parliament in its wisdom, it can be argued, did not prescribe any limitation at all. Many legislations are there. No limitation is prescribed. But where limitation is prescribed for initiation of the proceedings, and if that proceeding is initiated but not accomplished within the 6 months, then everything will go.
Yes, my lords. My lords, given the Delhi High Court.
ಎರಡು ಹಿಂಗೂ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಹಂಗೂ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಇಟ್ ವಿಲ್ ಅಕಾರ್ಡ್ ವಿತ್ ಓವರ್ ನಾರ್ಮ್ಸ್ ಆಫ್ ಅವರ್ ಸೊಸೈಟಿ, ನಾರ್ಮ್ಸ್ ಆಫ್ ಅವರ್ ಲೀಗಲ್ ಸಿಸ್ಟಮ್, ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗಿ. Because every citizen has got right to have sound sleep and beautiful dreams. If what you are going to do is affecting that, that's what Karak Singh said.
Yes, my lords.
Karak Singh versus State of UP. And now it is overruled and it's broadened, not overruled actually. It is
Expanded, my
broadened
lords.
in that privacy judgment.
21 is.
ಹಂಗಾಗಿ ನೀವು 10 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ಅದನ್ನ ಮಾಡಿದ್ರೆ ಅವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಜನ, ಇದೆಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ ಇದೆ.
My lords, the Delhi High Court, my lords, if I may say this, my lords. Yes, my lords. I'll just show that direct judgment, my lords.
ಇಷ್ಟೆಲ್ಲ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಇದ್ರೂ ಪಾರ್ಲಿಮೆಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಇಂಟರ್ವೀನ್ಡ್. ಆಲ್ದೋ ಎವ್ರಿ ಇಯರ್ ಇಟ್ ಪ್ರೆಸೆಂಟ್ಸ್ ದ ಬಜೆಟ್. ಅಟ್ ಲೀಸ್ಟ್ ಹಿಂಗ ಆಗ್ತಾ ಇದೆ. ಇದರಲ್ಲಿ ನಾವು ಏನೋ ಒಂದು ಈ ಕಡೆನೋ ಆ ಕಡೆನೋ ಮಾಡ್ಬೋದು ಅಂತ.
Para 13, my lord, just on the interpretation of law, my lords. On the facts, my lords, I'll just tell what are the dates of initiation, but para 13, my lords. In fact, when para 13, the last portion of para 13, my lords. From the above observation of Subodh Kumar Bhargava, my lords, does my lords have it, my lords? After the quotation, my lords. After the quotation of Subodh Kumar Bhargava.
Kumar, ಯಾವ page nation ಇಲ್ಲ?
There's no page numbers, my lords, in taxman.
Subodh Kumar, para 11.
Yes, my lords.
Recently in Subodh Kumar, para 11.
My lords, I'll skip all that, my lords. Para 13, my lords. Para 13.
Correct. The second part of section 275(1).
Yes, my lords.
Ada?
Yes, my lords. The last part of that para, my lords, is what I'm reading, my lords. Because they colored Subodh Kumar Bhargava's next.
From the above observations
Yes,
in
my lords.
Subodh Kumar.
It is clear that every penalty order under section 275(1)(c) emanates from the show cause notice / show cause notice. So the show cause notice, my lords, in this case was issued by Joint Commissioner 2017. However, such a notice may or may not arise in the course of some other proceedings. Where it does not arise in the course of some other proceedings, 2 periods of limitation will be available. One starting from the completion of other proceedings and ending with the end of financial year. The second starting from the end of the month.
One starting from the completion of the other proceeding.
Yes, my lords.
It's a condition. It's not a starting point. It's a condition.
Yes, my lords. That's the wording that they've used, my lords.
Just, I'm sorry to interrupt, my lord. I've read this decision. The distinguishing crucial fact is, in this case, the penalty order was passed admittedly 6 months after
This one, therefore, the
para 8, para 8, the notice was, I'll read it. The notice was issued on 26 June 1999. Order admittedly passed on 31/3/2000.
No, 16/3/2000, my lord. 16/3/2000.
Photo, it's beyond 6 months. That's the point.
16/3/2000.
So 275(1)(c) was violated. The facts are entirely different.
ಆ ರೀತಿ ಇದ್ದಾಗ very simple.
That's what the court
Because
said.
statute answers the question.
Yes, my lord. Beyond 6 months, my lords, is the point.
Question is not that.
The question is, what is the initiation point?
What is when
is the
initiation
point? Yes,
should
my lords.
happen?
When? No, my lord, initiation, my lords, according to this judgment, will start emanates from the issuance of show cause notice.
Appears to be sensible.
Yes, my lords.
Show cause notice by whom?
By the competent authority, my lords.
Competent authority. If that is beyond the period.
Yes, my lords. No, in this,
ಅದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ ಅನ್ನೋದು ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್. If Parliament wanted, it would have prescribed
so, my lords.
limitation.
the Kerala High Court also has taken a similar view, my lords, agreeing in 2015. And before this, Subodh Kumar also lays down the law, my lords. Subodh
Kumarದಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೆಂಗಿದೆ ಅಂದ್ರೆ
no, this is not
completion is beyond 6
Yes, my
months.
lord. No, Subodh Kumar was on different facts, my lords. They were incorrect, my lords. Subodh Kumar, this pass on Subodh Kumar.
ಅಲ್ಲ ಈಗ ನೀವು ಸೈಟ್ ಮಾಡಿದ್ದು
This is IKEA Capital, my lords.
ಡೆಲ್ಲಿದಿದೆಯಲ್ಲ
Yes, my lords.
ಐಕಿಯಾ ಟ್ರೇಡಿಂಗ್ ಹಾಂಗ್ಕಾಂಗ್ ಲಿಮಿಟೆಡ್ ಇದರಲ್ಲಿ ಆ ಕ್ವಶನ್ ಹೇಳ್ಬಾರ್ದು.
Because the order was passed admittedly.
Admittedly, the completion was after 6 months. Why all other things court discussed, that is only arbitral dictum ಆಗಿಬಿಡ್ತದೆ. ಆ ಕ್ವಶನ್ ಹೇಳಲ್ಲ ಆ ಕೇಸ್ನಲ್ಲಿ. ಆ ಕ್ವಶನ್ ಎದ್ದಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಕೋರ್ಟ್.
Yes, my lords. So Subodh Kumar Bhargava, my lords, I'll just pass.
ಇದೇನ ಇದ್ರ ಬರಲ್ಲ.
Subodh Kumar also have examined. The question there was under 275(1)(c), which of the 2 limbs would be attracted? If my lords recalls 275(1)(c), my learned friend read, there are 2 time limits. No order shall be passed beyond the end of the financial year in which the proceedings were initiated, or beyond 6 months from the action was initiated, whichever is later.
Whichever is later.
The court was called upon to interpret.
So again, it's a matter of, it's a post initiation.
Yes. So whether it is the first limb of C or the second limb of C. In my case, it is our case that it is the second limb of C which stands attracted. So again, the question of law in Subodh Kumar is different.
May I, my lord, Subodh Kumar for a minute, my lords.
ಕೊಡಿ.
Please look at my lords, para 1.
ಇದೇನು ಅರ್ಥ ಇಲ್ಲ ಇದ್ರಾಗ.
Yes, my lords.
ಅದರಲ್ಲಿ ಆ ಕ್ವಶನ್ ಹೇಳಿಲ್ಲ.
Para 1, my lords, the issue that having regard to Badr Durez Ahmed, my lords, the issue, my lords, that was before the court was, but having regard to the facts and circumstances, whether tribunal was right in law, holding the interpretation of provision 275(1)(c) of the Income Tax Act correctly and holding that the penalty order passed under 271(b) was within the limitation period. This was the issue, my lord.
ಇದು ಪ್ರಶ್ನೆ ಅಲ್ಲೇ ಇಲ್ಲ. Penalty order, see how section is, that is not our question at all. See, always I tell you, ನಮ್ಗೆ clarity ಇಲ್ಲ. There is one famous book, Art of Thinking Clearly. by Dobelli, a great Jewish author, has written, clarity in thought illa andre ಬಹಳ misdirection in law ಆಗ್ತದೆ. Very famous book ಅದು, very beautiful book. ನಮ್ಮಲ್ಲಿ ತರ್ಕಶಾಸ್ತ್ರ ಇತ್ತಲ್ಲ, ಅದನ್ನ ಓದ್ಕೊಂಡ ನಂತರ ನಾವೆಲ್ಲ ಬೇರೆ ಗ್ರಂಥಗಳನ್ನು ಓದ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾನೆ ಮನು. ಹಾಗೆ ಯಾವ್ದಾರೆ ಏನೋ ಮಾಡ್ಕೊಂಡು ಅಂತಾರೆ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡಬಾರ್ದು ಅನ್ನೋದಕ್ಕೆ he has prescribed ಯಮ, ನಿಯಮ, ತರ್ಕ, ಮೀಮಾಂಸಾ, ಛಂದಸ್ಸು ಇವನ್ನೆಲ್ಲ ಓದ್ಕೊಂಡು, ವ್ಯಾಕರಣ ಇದನ್ನೆಲ್ಲ ಓದಿದ ಮೇಲೆ ನೀವು ಬೇರೆ ಗ್ರಂಥಗಳನ್ನು ಓದಬೇಕು. ಅದೇ ರೀತಿ ಲಾದಲ್ಲಿ ಹಂಗೆ ರೂಪರ್ಟ್ ಕ್ರಾಸ್ ಹೇಳೋದೇನು ಅಂದ್ರೆ, ನಿಮ್ಗೆ ಆಕ್ಚುವಲ್ ಕ್ವಶನ್ ಏನ್ ಎದ್ದಿದೆ ಅದನ್ನೇ ರೇಸ್ ಮಾಡಬೇಕು.
No, that issue, my lords, is not settled by any court.
By any court at all.
By any court, no, my lords, Delhi High Court was a court of writ petition.
I'm sorry.
I'll go through the Delhi, I've gone through the Delhi High Court decision, my lords, of 2024. Yes, my lords.
ಅದ ಬದರ್ ದುರೇಜ್ ಅಹಮದ್ ಜಜ್ಮೆಂಟ್ ನೋಡಿ.
Yes, my lords.
ಕ್ವಶನ್ ನೋಡಿ ಏನ್ ಫ್ರೇಮ್ ಮಾಡ್ಯಾರ ಅನ್ನೋದು. Current holding that penalty order passed under section 271B was within the limitation period, not initiation of penalty proceedings.
No, initiation.
In our case, though substantial question of law, which is required to be framed by you, is wrongly framed. We don't agree with that, because there are judgments of Justice Nariman holding that such cases will not be questions of law at all. Questions of law, especially substantial questions of law, ಹೆಂಗಿರ್ಬೇಕು ಅಂದ್ರೆ, answer to that question should upset the order who is put in challenge. ಆ ಕಾನ್ಸೆಕ್ವೆನ್ಸ್ ಇರಬೇಕು. ಆ ಕಾನ್ಸೆಕ್ವೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ substantial question of law ಆಗಲ್ಲ. So many questions may arise in an appeal. Only substantial question of law. It is almost like a section 100 of our CPC. That's how we have written that.
260A also is under section 100 of CPC.
100 of CPC, equate my bit now.
There's no point.
Okay. Now question ಹೆಂಗಿರ್ಬೇಕು ಅಂದ್ರೆ, whether two questions ಹೇಳ್ತಾರೆ. Whether is there a limitation period prescribed by 1961 Act for initiation of penalty proceedings? Number one.
Yes, please.
If answer to above question is in the negative, then whether the initiation of penalty proceedings in the case at hand can be said to be within the reasonable period because of judgment of the apex court in Nekkanti versus state of Karnataka. In state of Karnataka, Nekkanti, ಅದು ಗೌರಮ್ಮ ತೆಗಿರಿ judgment, court of Dharwad bench. In the apex court said, whether limitation should be prescribed or not is a statutory policy.
Yes,
even rule making power authority cannot prescribe, and court cannot, because we are not making the law. It's a matter of policy. Number one, where no limitation is prescribed, does it mean that whatever was done when Alexander had come here, that can be put in challenge before the court? No. Then doctrine of reasonableness would step in. This is how Nekkanti runs. The whole philosophy of Nekkanti is the PTCL Act did not prescribe any limitation for seeking restoration of
Section 5.
granted land sold to somebody.
Yes, my lords.
Without leave of the government, permission of the government. There the apex court, earlier the 2-3 judgments, Justice Anwar, Justice Mirde, and Justice G.P. Shivaprakash, all these judges had held there is no limitation at all.
Yes, my lords. In fact,
Supreme Court said, yes, there is no limitation. That does not mean after years you can get up, wake up from your slumber and shoot an application for seeking restoration of the land. Where no limitation is prescribed, the doctrine of reasonableness should be invoked ಅಂತ ಹೇಳಿ. ಅದೇ ರೀತಿ ILR 1986 Supreme Karnataka 1058. Similar, almost similar question. Under 136(3) of the Karnataka Land Reforms Act, there is no limitation for invoking revisional jurisdiction. Land Revenue Act. That's called Murugarajendra case, DB, Justice Ramajoy's judgment. Section 136(2) of the Land Revenue Act prescribes a period of 30 days or 60 days for preferring the appeal, 60 days. But that is not there in 136(3). In that case, after 20 years, they had invoked revisional jurisdiction, saying that, no, there is no limitation at all. The court said, where the 60 days time is prescribed for appeal, then ordinarily 60 days should be presumed to be reasonable for invoking the revisional jurisdiction. So it is not that. That is where limited. Now they have amended it.
Yes, my lords. Subject matter
PTCL.
challenge also, my lords.
So that came before me whilst I was in the bench in Dharwad. The section says there shall be no limitation for filing application for restoration. That is the law. What Supreme Court said, what judges said, legislators ought to say. No change of law at all. We've interpreted limitation is not applicable does not mean doctrine of laches is not applicable. Doctrine of laches is the cousin of doctrine of reasonableness. They go hand to hand.
My lords, in fact, my lords, I've also impugned that section, my lords, before the coordinate bench, before single judgment, my lords, learn a single judge, my lords, actually coming up on 10th. My lords, we've used this particular DB judgment, my lords, to also canvass this issue, my lords, before the court. Because, my lords, the judgment gives us some sort of leeway or some sort of direction, my lords, as to how to attack the section 5 provision, my lords, sir.
5 of Limitation Act.
No, my lords, the PTCL Act, my lords.
PTCL Act.
Yes, my lords.
No, we have already interpreted. No.
But my lords have also said that, my lords, I'm not coming in the way of the challenge to
That's
the section.
true.
Yes, my lords.
Because challenge was also late.
Yes, my lords. Challenge is ongoing.
We said, well, we are not, because it's being examined another,
And that the...
So now, after reading these provisions, we are not finding any legislative prescription of limitation for initiation of the proceedings. Although for accomplishment, there is such a prescription. 6 months or within the period of that another order made something there, whichever is longer, later. Other. But initiation is number 1. Initiation illa andakshana, latches and reasonableness. Our facts bekagat namak.
Yes, not.
What is, whether it is reasonable or not. Yes, this is the judgment where we said that. Because limitation is a matter of legislative policy. This is how I have written the judgment. Latches is a matter of judicial conscience. Differentiate to Mandel. There was one Justice Hidayatullah's judgment. I remember because that was in July 2024. Para G 30. Idನ್ನು invoke ಮಾಡಬಹುದು. Just see that. Read loudly. There are some students, interns students irtare.
There is a marked difference between delay and latches that operate in equity and limitation and delay that obtain in law. The following observations of Apex Court in the Union of India versus Murugation make out this point. Delay, latches, and acquiescence. Para 20, the principle governing delay, latches, and acquiescence are overlapping and interconnected on many occasions. However, they have their distinct characters and distinct elements. One can say that delay is a genus to which latches and acquiescences are species. Similarly, latches might be called a genus to a species by name acquiescence. However, there may be a case where acquiescence is involved, but not latches. These principles are common law principles, and perhaps one could identify that these principles find a place in various statutes, which restrict the period of limitation and create non-consideration of condonation in certain circumstances. The underlying principle governing this concept would be one of estoppel. The question of prejudice is also an important issue to be taken note by the court. Latches. The word latches is derived from the French word meaning remissness and slackness. It thus involves unreasonable delay or negligence in pursuing a claim.
French court said like that. Yes, therefore, I quoted that. Yeah.
It involves an unreasonable delay or negligence in pursuing a claim involving an equitable relief while causing prejudice to the other party. It is neglect on the part of the party to do an act which law requires while asserting a right and therefore must stand in a way of the party getting relief or remedy. The two essential factors to be seen are are the length of the delay and the nature of the acts done during the interval. As stated, it would also involve acquiescence on the part of the party approaching the court apart from the change in position in the interim. Therefore, it would be unjustifiable for a court of equity to confer a remedy on a party who knocks his door when its acts would indicate a waiver of such a right. By this conduct, he has to put the other party in a particular position, and therefore it would be unreasonable to facilitate a challenge before the court. Thus, a man responsible for his conduct on equity is not expected to be allowed to avail a remedy. That is the paramount.
Yes, that's how we structured that judgment. Now, once we come to an agreement, broad consensus, that there is no statutory limitation for initiation, then we have to see whether this is initiated within reasonable
Yes,
time. Let us see. Now, but once initiated, it is completed within 6 months.
Yes, my lords.
That's also not there.
Once initiated by the second show cause notice.
Very good.
There's only one show cause notice, my lords.
That is, there are no dispute about that.
Yes, it's
Okay.
within 6 months of time.
So the fulcrum of the case is initiation of the penalty proceedings.
Yes, my lords.
That's all.
In the brief note, my lords, there's one Karnataka High Court judgment, my lords, of the division bench. May I just pass it on, my lords?
But
I'll just pass it on.
answering the same question.
Or arising of a similar issue, my lords, on initiation.
Question
penalty.
it.
Question, my lords, whether on facts and circumstances of case, the tribunal was right in holding that penalty proceedings initiated on June 8, 1993, and completed on 15 December 1993, were beyond the period of limitation. That is the question, my lords. Because is a more than 3-paragraph order, my lords, which
But-
says, yes, my lords.
But the our judges, sir.
Lords, this is my lords, Justice
Rajan and Jawad.
Yes, my lords. Guru Rajan and Jawad Rahim, my lords,
Yeah.
as they were. My lords, in this case, my lords, assessment order, I'll read paragraph 5, my lords. The admitted facts would reveal no audit. The same is noticed by the tribunal. After noticing, the tribunal was of the view the penalty could not have been levied, since according to tribunal, it was issued 14 months after the accomplishment of assessment and affected by limitation under 271B of the Act. The said section provides for levy of penalties and quantum of penalties in terms of section 271B, read as under. Para 6, my lords, time limitation. The time limitation is prescribed in terms of 275(1) of the Act. We're only concerned with 275(1)(c) of the Act. The same reads as follows. In any other case, after expiry of financial.
You have read that.
Yes, my lords.
Right.
So para 7, a combined reading of 271B and 275(1) clause C would show the 6 months period of limitation is with reference to initiation of proceedings in terms of 275(1)(c) of the Act.
1 second, read it again.
A combined reading of 271B and 275(1)(c) would show the 6 months period of limitation is with reference to initiation of proceeding in terms of 275(1)(c) of the Act. In the case at hand, it seems that initiation was done on June 8, 1993, and the penalty was levied on 15 December 1993. It is within the 6 months from the day of initiation of penalty proceedings.
Penalty was levied.
Yes, my lords.
So it amounts to accomplishment
Yes, my lords.
of accomplishment of the proceeding.
Within 6 months, my lords, I have to.
Initiation is ಸಂಬಂಧಪಡೋದಿಲ್ಲ.
Yes, my lords. Initiation is.
Question is framed that way.
And again,
Initiation is ಸಂಬಂಧಪಡಲ್ಲ.
Yes, my lords.
And again, the vital distinction is 271B is the penalty in question in that judgment. 271B, the assessing officer himself can impose.
Can do
penalty.
that.
So there is a
Not the
distinction.
joint
Not the
commissioner of
commissioner,
income
because
tax.
his answer is, his contention is that the AO could not impose penalty, so don't disregard his reference, look at only the joint commissioners. In 271B, the AO himself can do so. So again, it's distinguishable very clearly on facts.
No,
Those
even otherwise.
Yes.
ಇದ್ರಾಗ accomplishment ಮೇಲೆ ಇದೆ.
Because the
Though
board-
question is framed that way, answer is gone on
Yes, ma'am.
accomplishment.
Because the board, my lords, has issued circular, my lords. I'll just bring it to the notice of my lords, my lords. What has the board said?
Yes.
You have this board notice? Yes.
Board circular ಏನ್ ಮಾಡ್ತಾರೆ?
The board circular, my lords, has noticed that there's a lot of interpretation by different high courts and has suggested to the officers, my lords, as to how to go about it.
ನೀವು ಡೆಲ್ಲಿ ಒಳಗಿದ್ರೆ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಫಾಲೋ ಮಾಡ್ರಿ, ಕರ್ನಾಟಕದ ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ರೆ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಫಾಲೋ ಮಾಡ್ರಿ, ತಮಿಳ್ನಾಡಿನಾಗಿದ್ರೆ ತಮಿಳ್ನಾಡು ಮದ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಫಾಲೋ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದಾರೆ ಏನು?
No, no, my lords.
ಎಷ್ಟು ಇದ್ರಲ್ಲೆಲ್ಲ
This, my lords.
No, actually, what my lord said is precisely what they've said. If my lord will see para 5 of that,
ಇದೆ.
I'll just read the first two, my lords, because that's important, my lords.
where any high court decides this issue contrary to department view, that we shall, it's precisely.
They have
what
said
my
the
lord
same
said.
thing.
No, my lords, please look at para 4, my lords. Please look at para 4. Please, because my lords, para 5, my lords, if you read independently, my lords, it gives conveys different things. May I just read para 1, my lords? Why was the circular issued?
ಈಗ ಗೊತ್ತಾಯ್ತು ಬಹಳ ಕಾನ್ಫ್ಲಿಕ್ಟಿಂಗ್ ವ್ಯೂಸ್ ಇತ್ತು ಅನ್ನೋದಕ್ಕೆ
Yes, my
ಇಶ್ಯೂ
lords.
ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
So the Kerala High Court rules, my lords, in the favor of the revenue. In fact, my lords, some High Court, para 2, my lords, may I just read 4 lines, my lords? Some High Courts have held that limitation commences at the level of authority competent to impose penalty, that is range head, while others have held even the assessing officer is not competent to impose penalty, the limitation commences at the level of assessing officer, where assessing officer has issued show cause notice or refer to initiation of proceeding assessment order. On careful examination, my lords, the board is of the view that for sake of clarity and uniformity, conflict needs to be resolved by way of departmental view. The para 3, my lords, is the judgment of the
Kerala
Kerala
High
High Court. Kerala High Court, no, the rules in favor. The above judgment reflects departmental view. Accordingly, the assessing officer below the rank of joint commissioner may be advised to make a reference to the range head regarding any violation of.
That is only as to who should do that.
Because further, my lords, just that one paragraph. Any violation of provision of section 216 SS and 269T of the Act, as the case may be, in the course of assessment proceedings or any other proceedings under the Act, assessing officer below the rank of joint commissioner shall not issue notice in this regard because it doesn't have the powers. The range head, that is joint commissioner, will issue a notice of penalty and shall dispose, complete the proceeding within a period of limitation prescribed under 275(1)(c), that is 6 months. So joint commissioner should be the one, my lords, initiating the penalty proceedings.
Some question will answer.
Yes, sir. My lords, that
Who should do ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರು ಅಷ್ಟೇ.
Can I just say because that is crucial, because the date of the circular, my lord, is 26th April 2016. Para 5, the following, I'll just read thereafter. Where any High Court decide, I won't read that first sentence. However, the CCIT concern, the second sentence, my lords, in para 5.
Where any High Court decides.
This issue contrary to department view, the department views thereon shall not be operative in the area falling within the jurisdiction of the relevant High Court. This is crucial. However, the CCIT concern shall immediately bring the judgment to the notice of the Central Technical Committee. The CTC shall examine the judgment on
Filing
prior
SLP.
to decide whether to file. Now, after this circular, there are
No,
6
this is like
yes.
when Apex Court struck down that Me Too versus State,
Yes.
where they have struck down attempt to suicide is not an offense ಅಂತ ಮಾಡಿದ್ರು.
Yes,
Bombay
lords.
High Court.
Yes.
Some police case ನಲ್ಲಿ.
Please, please.
Those who wanted to commit suicide, if they were not sure that it would be completely done, they used to go to Bombay and the Maharashtra area and try. If they succeed, well and good, nothing can be done. If they do not succeed, they would come back very
to
safely.
Safer jurisdiction.
Because in Bombay area, Bombay High Court has said like this, therefore there is no offense. ಹಂಗಿದೆ.
So I just wanted to point out, after this circular where they say, if you disagree, please file an SLP. 5 Delhi High Court decisions have been passed in the SSC's favor. None of those 5 have been taken in appeal to the Supreme Court. I read this one writ petition, my lords correctly observed, it's only SLP dispute. But the other 5 are all income tax appeals, where one of them, the question was, when is the initiation set to be? Is it the reference made by the AO to the Joint Commissioner or the issue of the notice by the, sure. And that the Delhi High Court, as recently as November last year, November 2024, have held that it is when the reference was made by the AO to the Joint Commissioner and thereafter. None of those 5 have been challenged by the revenue, and they're all appeals. The same question of law was there, and the benefit of the monetary limit circular cannot be taken because in penal proceedings, they have no monetary limits. That is why, in fact, even in this case, the appeal is still pending. So if they've accepted it, not only in the light of monetary limits, but in the light of this circular, they cannot be seen to take a different view here, apart from the binding nature of those 5 decisions.
Those judgments will have to be looked into, my lords.
Yes,
What
I'll
are the
take
questions? That will have to be looked into, my lords, because what my lords are saying is there a date for initiation? The answer is no, my lords.
ಅದಿಲ್ಲ ಇಲ್ಲ.
Yes, my lord. That is not, my lords. Who is a competent authority?
Who is
my lord?
competent ಅನ್ನೋದಕ್ಕಿದೆ.
That, my lords, that is.
We have opened that.
Yes, my lords.
When to be completed once initiated.
That is
ಇದೆ.
also answered, my lords.
But when to initiate, within what period to initiate, ಮೇಲೆ silent ಇದೆ.
Yes, my lords. If that answer, my lords, that, my lords, in our respectful view, has not been answered by any courts for the reason, my lords,
No
there's
court
no
has answered
initiation.
With my liberty, just try to reframe the question, which according to me may arise. Initiation, if the initiation is by an officer not competent to pass the order,
It is no
is it
initiation.
still initiation for the purposes of 275(1)(c), or is it said to be initiated only when the officer competent to pass the orders issue the notice?
Correct.
That is because his case is, since the AO was not competent to pass the order, his reference is invalid, disregarded for the purpose of limitation. Our cases is that you
No,
cannot.
reverse you are saying.
Yes. No, I was saying what he was saying, reverse, yes, precisely. So merely because the assessing officer is not competent to pass the order, does it mean that his reference, which is admittedly based on which the subsequent notice is issued, should be disregarded for the purpose of limitation?
It was reference to whom, my lords? Is the officer even involved at the time of reference? It is an
He sits
internal
on- he
communication.
sits on it for 1 year.
It is an internal communication
It will be
between.
within 1 year.
Yes, 1 year.
Yes, in this case.
360 days. 16, 11, 16, the reference is made to the JC. 10, 11, 17 issues the notice. What in the 1 year?
But then that is beyond 6 months and therefore it cannot be ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ. ಅದ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಯಾಕಂದ್ರೆ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ನಲ್ಲಿ ಅದನ್ನ ಹೇಳಿಲ್ಲ.
Yes, my lords.
ಇದು ಒಂದು. ಅಜ್ಯೂಮಿಂಗ್ ಮತ್ತದು another ಲಿಂಕ್ ಇದೆ ಈ ಕ್ವಶನ್ ಗೆ. If 16 ಏನದು
16, 11.
16, 11.
Yes, ma'am. 16.
16, 11, 2016.
Yes.
If that is the reckoning period, then it will be beyond 1 year ಆಗ್ತದೆ.
It will be beyond 6 months or 1 year.
Beyond,
Yes,
whichever,
Yes, my lords.
depending upon in which your case falls. ಅವಾಗ again you will be benefited only
Yes, my lords.
because completion is not done within 1 year another.
Yes, my lords. That is true, my lords.
Right. But if that is accepted, then it goes to the initiation itself. ಅಲ್ಲಿದೆ ಏನ್ ಮಾಡೋದು? ಇದು ಒಂದು ರೀತಿ ಏನೋ ಬರೀ vexed question ಇದೆ.
Yes, my
In
lords.
fact, a similar appeal came up, I understand came up today before my lord, but it's been adjourned by 2 weeks.
That has not been admitted yet, my lords.
That is
They
at
have,
stage of admission.
ನಮ್ಮ ಮುಂದ
yes, my lord. Item
Give or take
31,
to
item
serial
31, my
number
lords.
31.
They took time, my lords, today.
ಅಲ್ರಿ ಈಗ ಹಿಯರಿಂಗ್ ಆಯ್ತಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ
Yes,
ಬೇರೆ
ma'am.
ಏನಾರ ಹೇಳಿಕ್ಕಿದೆಯಾ?
No, no, my lords. Nothing.
My written submissions are.
ಕೊಟ್ಬಿಡಿ. ಕೊಟ್ಟಿರ್ಲಿ ಇದೆ.
Yes, in fact, I've,
Hadri,
and all the judgments, I've referred to the para
I
number.
have,
ಒಂದು
I have,
sentence ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಹಂಗೆ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. There is a broad unanimity as to the 1961 Act not prescribing any period of limitation for initiating the penalty proceedings. Although there is one for accomplishment of such proceedings once initiated. First, there appears to be unanimity at the bar that the question as to whether there should be limitation or latches in adjudging validity of initiation of penalty proceedings. First, one possible view is that when lawmaker does not prescribe limitation to do a certain thing, comma, that can be done at any point of time. First, the other, if this view is extreme and would put the citizens to possible difficulty, comma, then the other view is even when no limitation is prescribed, the concept of latches, delay and latches would be invocable, applicable. First, if that is applicable, then we have to delve into the fact matrix of the case, which essentially is given at the para 4 of assessee's written submission. Para 4 all another?
3 and 4.
3 and 4 of assessee's written submission. Refer to
There was this one judgment that I wanted to refer, my lords. Just one more, only one more.
Tam Pedda Guruvareddy.
Yes, ma'am. That's the Karnataka High Court, my lords.
Refer to coordinate bench decision in Tam Pedda Reddy, Pedda Guruvareddy. Then Kerala High Court judgment.
Not pass the Kerala High Court judgment, no, I'll just pass it on.
But
Para 10, my lords.
ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು?
My lords, they say, my lords, the question, my lords, if I may just take, my lords. Para 10. The question to be considered.
ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಆಡ್ ಮಾಡ್ಕೋಬೇಕಲ್ಲಿ. Incidentally, the question arises as to who is competent to initiate penalty proceedings, and when this proceeding is initiated,
Yes, my lord.
comma, and by whom?
Yes, my lords. But para 10, my lords, of the Kerala High Court. That will throw some light, my lords.
Para 10.
Yes, my lords. So the department is also taken over, my lords. Question to be considered. Internal page 3, my lords.
Correct.
Yes, my lords. Question to be considered is whether proceedings for levy of penalty are initiated with the passing of the order of assessment by the assessing officer, or whether such proceedings have commenced with the issuance of the notice issued by the joint commissioner. From the statutory provision, it's clear that competent authority to levy penalty being the joint commissioner. Therefore, only the joint commissioner can initiate proceedings for levy of penalty. Such initiation of proceedings could not have been done by the assessing officer. The statement in the assessment order that the proceedings.
They say joint commissioner issue ಮಾಡಿದಾಗ ಆಗತ್ತೆ ಅಂತ ಹೇಳ್ಬೋದು. That appears to be sensible
Yes,
also.
The latter part of that particular paragraph, on the other hand, the code also deals with the truth.
Yes, I read that.
Yes, my lords. That's all.
That's for 5 minutes. I just take this Delhi High Court decisions.
ಅಲ್ಲಿ refer to CBDT circular,
Yes, my lord, CBD circular.
circular
Departmental review.
dated 26/4/2016. Delhi High Court judgment in Subodh Kumar Bhargava. ಏನಿದೆ ಆನ್ಸರ್ ಮಾಡಲ್ಲ ಇದು.
Because they, my lords, deal with the entire section 275(1)(c), my lords.
ಕರೆಕ್ಟ್, ಆ ಪಾಯಿಂಟ್ ಅನ್ನು ಬಿಟ್ಟು ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
That initiation, my lords, yes, my lords, I agree.
ಅದೇ ನಮ್ಗೆ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗ್ತದೆ ಈಗ.
That point, my lords, has not been answered, my lords, by anyone. My respectful submission.
You wanted to say something.
In fact, in the written submission, I've referred to the relevant paragraphs, but I'll just read the latest decision where this question was framed and answered. It starts at page 34 of that compilation.
34 of compilation.
CIT versus Turner General, my lords have that.
Please look at para 12, my lords. 14 years, my lords, after 14 years, department issues a notice. But I would not come in that way, my lords. 14 years and all, no one can defend, my lords. Para 12.
No, that's an earlier order which you referred to.
Delhi idರಲ್ಲಿ.
Yes, my lords. Page 31, my lords, at para 12.
What, brother, what do you want to
Yes,
say?
my lords, may kindly see page 35, para 10, my lords. And there's no 14 here. I think there's some mistake, my lord.
I was referring to page 31.
Yeah, I'll just read it. Para 10, my lord, sir. On page 35.
Principal question
is to be answered is whether the penalty proceedings were initiated on receipt of reference on 25/9/14 or on issuance of show cause notice on 4/8/14. So there's a 1 month gap. I don't know where 12 years came. The question as to whether a penalty proceeding can be stated to be initiated is clearly covered in favor of the SSC by the decision of this court in PCIT versus JKD Capital Finley. I have placed that as compilation number 1. Then they refer to that one. Then para 12 may kindly be seen, page 37. Mr. Sharma, my lord, have that? Page 37.
Sharma.
Mr. Sharma, the learned counsel appearing for revenue, sought to distinguish the case of PCIT JKD on the ground there that the case in the delay was over 5 years. However, we are unable to accept that the ratio decided of the said decision is inapplicable in the facts of this case. Although the delay in JKD was more than 5 years and there was no explanation to the said delay, the said decision also rests on the principle that the initiation of penalty proceedings cannot be delayed in an arbitrary manner. And the initiation, I'll just see, in this case, he goes on to deal with when is it said to be initiated, and it was a case of 1 month in this case.
No, then this involves latches on,
Yes.
not limitation.
Not limited.
Even Supreme Court agrees that there is no limitation. Therefore, it says merely because there is no, you cannot do it arbitrarily whenever you want.
My learned friend is fair enough to consider if it was more than 5 years and all, yes. I think even he was fair, but there are cases where there's 1 month delay also, the courts have come.
Latches, it involves a host of factors.
In my
It's already Shetty, I think one week delay in filing writ petition.
Yes, Lord.
So dismiss the writ petition, having held so many principles.
That's also because, my lords, the petitioner's fate accompli, my lords. The tender is already given.
That's what.
That's the reason, my lords.
Correct, correct.
I won't trouble my lord to know, but in my submissions at para 16,
The initiation of proceedings must be considered as on the date on which reference was made to the concerned officer, if not earlier. Reference was made to the concerned officer means competent officer.
Yes, ma'am. Please look at para,
JCIT.
please look at para 4, my lords, of the said judgment.
Then not when just JCIT issues the notice.
No,
in
para
our case,
4.
it is 16/11/16 and not 10/11/17.
Mas para 4,
That's
my-
what.
Yes, precisely what my lord.
para 4, my lords, deals with the fact the joint commissioner in this case sat for 11, almost, my lords, for considerable period of time. Para 4. The
That's true.
The concerned JCIT did not take any steps to issuance of show cause notice for para 4.
For
my lords.
years.
Yes, bros. Para 4, my lords. So that's page 34. Page 34, my lords. The same judgment on why Mr. Bakru, my lords, writes a judgment of this nature.
It's less than, it's 9, it's 11 months, 10 months, which is less than what is before my lord, it's 1 year in my case.
Less than that.
That case, they sat on it for 10 months. Here, they sat on it for 1 year. 25/9/14 to 4/8/15, which is less than 10 months or 10 months and 10 days. Nam case, they sat on it for 1 year.
ಇಲ್ಲಿ penalty order is barred by limitation is the question.
Yes, my lords.
In which one?
Yes, my
It
lords.
in relation to initiation,
Yes, the question frame, I just read that one, at page 37. The
that's
question-
what. Para 12.
Para 12, yes, sorry, page 35. The principal question to be answered is whether penalty proceedings were initiated on receipt of reference on 25/9/14 or on issuance of notice on 4/8, it should be 15. There's a typo. The previous page I've written 4/8/15.
No, even that is not the question which you are arguing now.
Yes, my
I'm arguing that only, Manoj.
Because
I'm
that,
arguing that the
if
initiation-
the reference date is taken,
Yes,
then it is beyond limitation.
yes, that is my contention before my lords. is
No,
that-
in two aspects you are there. Reference by an officer,
Yes,
presumably ITO,
yes, please.
to the JCIT. That reference date is taken, it is beyond the period is one thing, if that is so taken. And it appears to be held that way. This is a Delhi High Court.
Delhi High Court, yes,
Delhi High
division,
Court.
division.
We are not only on that point. When that answers the question, when the proceedings are initiated, if that is taken, then initiation may be saved, but accomplishment would be beyond the period.
Yes, my lords.
Again, you have a difficulty there, either way. Suppose, since there is no, you are saying the initiation should be taken from the date the reference was made by the ITO to the JCIT.
I'm not saying that, my lords.
I'm saying.
No,
Yes,
his contention.
yes, my lords. Yes, my lords.
If that is considered, the accomplishment of the proceedings would be beyond 1 year.
Yes, my lords. That's
Number one.
Yes.
Number two, if we take the view that initiation of the proceedings would be when JCIT issues notice,
Yes, my lords.
because
Competent authority.
clause 1,
Yes, my lords.
clause 1 of that section says, without here giving an opportunity, you cannot do.
He's given me an opportunity.
Ha. Therefore, if that is taken, then It will be,
6 months from the time of no show cause notice, my lords.
within what period it will be?
It will be within 6 months.
Then it will be within 6
My
months.
order is within 6 months, my lord, from the day of show cause notice.
After this also,
Yes,
question arises, within what period initiation should take place?
Because the judgment, my
Those
lord,
three types of case questions will arise. Understood.
because para 35, my lords, in this case, page 35, my lords, para 5, what did the CIT appeals to, my lords? CIT appeals noted the terms of 275(1)(c) of the Act. No order imposing penalty could be passed after expiry of 6 months from the end of the month. Now, my lords, this was the case, my lords, where order was passed beyond 6 months. In our case, my lords, order was passed within 6 months from issuance of show cause notice. That is a distinguishing factor, my lords.
But when you initiated, what is the
I
delay?
initiated, my lords, on the November 2017, my lords. I'll just give the date, my lords.
10/11/17.
10/11/17.
10/11/17.
And I passed the order, my lords, within span of 3 months, February 2018.
That is accomplishment is all right.
Yes, my lords.
But when you ought to have initiated the proceeding?
I
according
have
to
to have initiated, my lords.
According to me, man, I am not,
You are not much on
on
initiation
that.
period at all.
I'm much on the fact that, my lord, that you cannot disregard the initiation by the AO. It is
Because
not-
of Delhi High Court judgment.
And in the show cause notice, which is issued subsequently by the JCAT, he refers to the AO's notice. It is his satisfaction which he borrows and issues the notice. If it were not for the AO, he would not even have the show cause notice and.
So as between you, the point will boil down to this. Whether initiation is when the reference is made or when the notice is issued.
Yes, my lords. That's the precise.
That boils
question.
down to that one.
That is the
But
precise question, my lords.
in my submissions, I framed the question like that also.
Okay.
Page 5.
All right. Thank you.
I'm grateful, my lords.
Thank you.
Result.
My lords, I've filed a brief note, my lords. I'll also substantiate the written submission, my lords, by Monday, my lords. I've said what are the 5 points of revenues contending. I can also file a detailed note, my lords, calling out the paragraph of judgments.
Monday further hearing hakolla.
Yes, my lords.
Avut ಮಾಡಿ ಕೊಡ್ತೀರಾ?
Monday, they have filed it, my lords. I'll file it in registry, my lords.
Reserve ಮಾಡೋದು ಬೇಡ. Just call it for further hearing on Monday.
Monday, my lords.
Okay. Because it will have consequences
Yes, my lord.
for the country.
Yes, my lord.
Okay.
I'm grateful.
ಬೆಂಚ್ ಇರಲ್ಲ.
ನೀವು ಪೆನ್ ಮೇಲೆ ಇದ್ದೀರೇನೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್
Income tax.
ಓ ಹಂಗಾರೆ ಎರಡೂ ಕಡೆ ಮಾಡ್ಬೇಕು
ಇತ್ತ ಸರ್ ನಿಮ್ದು ಇವತ್ತು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇತ್ತ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇತ್ತ
ಇಂಜಿನಿಯರಿಂಗ್ ಇತ್ತು ಅಂದ್ರೆ ದಟ್ ವಿಕ್ರಮ್ ಆದಿತ್ಯ ಭಟ್ he is gone to that ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವು ಎರಡು ಪುಸ್ತಕ ಹೇಳಿದ್ರಲ್ಲ ಹೆಸರು ಬೇಕಾಗಿತ್ತು
ಸರ್
ಎರಡನೇದು ಕೋರ್ಟಿಂಗ್ ವಿತ್ ಡೆಸ್ಟಿನಿ
ಹಾ
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಲೀಗಲ್ ಹಿಸ್ಟ್ರಿ ರಾಮಾನುಜನ್
ರಾಮ ಜಾಯ್ಸ್ you written down confirm it one second
Now you will be there for DB or?
no I am given a single single is your
ನನಗೊಂದು ಕಾಪಿ ಅಲ್ಲಿ ಬಿದ್ದಿತ್ತು ಅದು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಸೇ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಇನ್ ದ ಕಾರಿಡಾರ್ ಟು ದ ಯಂಗ್ ಅಡ್ವೊಕೇಟ್ಸ್
ಇವ್ರದ್ದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ನಿಮ್ಗೆ ಬರ್ತೈತಲ್ಲ ಇವ್ರು ನಿಂತಿದ್ದಾಗ ಅದನ್ನ ಹಾಕ್ಸೋನು ಡಿಲೇ ಇಟ್ ಇಸ್ ಇಸ್ ಓನ್ ಸಜೆಷನ್
distribute it in the corridor. Why you give it library?
Open.
Give it to court, give it to the court clerk. Court clerk will distribute to me. I will not judge says you give to that advocate.
ಈಗ ರಾಮ ಜಾಯ್ಸ್ ಪುಸ್ತಕ ಬಹಳ ಚಿಕ್ಕದಿದೆ ಅದಕ್ಕೆ ಅದ್ರದ್ದು ಒಂದು 5 ಸೆಟ್ 12 ಸೆಟ್ ಅಂದ್ರು ಇಲ್ಲೊಂದು 2 ಸೆಟ್ ಎಷ್ಟು ಅಂದ್ರು
ನಾಳೆ ಟ್ಯಾಕ್ಸ್ ನಾಳೆ ಇಲ್ಲ
ಬೆಂಚ್ ಇಲ್ಲ
Saturday ಎಲ್ಲ ಇದಕ್ಕೆ ರೀ ಸಾಟರ್ಡೇನಾ ಇಲ್ಲೂ ದೂರ ಕೊಡ್ರಿ ಸರ್ ನಮ್ಮ ಆದಿತ್ಯ ಭಟ್ ಬರ್ತಾನ ಒಂದ್ ಸ್ವಲ್ಪ ಇವತ್ತಿನ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಎಲ್ಲ ಒಂದು ದೂರ ಕೊಟ್ಬಿಡ್ರಿ
ಇವರು ಸ್ಟೆಪ್ನಿ ಬಟ್ ಎಲ್ಲ ಲೀವ್ 16
ಇದು ಕುಂಭಕ್ಕೆ ಹೋಗ್ಯಾನ ಮಾಕುಂಬ
16 ಬರ್ತಾರ ಅವ್ರು ಆಕ್ಚುಲಿ
16th why take a chance take 20th ಮಂಡೇ ಕೊಡ್ಸ್ರಿ ಮಂಡೇ 20 ಕೊಡಿ ಆರಾಮಾಗಿ
ಐಡಿಯಲ್
ನಿಮಗೆ ಐಡಿಯಲ್ ರೀ 20th ಕೊಡ್ರಿ ಬ್ರೀತಿಂಗ್ ಸ್ಪೇಸ್
ಧಾರವಾಡದಲ್ಲಿ
21st ಕೊಡಿ
ಪರವಾಗಿಲ್ಲ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರ
ಮತ್ತೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ
ಅದಕ್ಕೇನಿಲ್ರಿ
ಆಯ್ತು
ಅಲ್ಲ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
16th at he's asking 46 is adjourned to 16th remaining when is he coming that's what
15 is back. Sorry, he is red out. He's got 10 juniors. All doing
all research and back end
ಇವತ್ತೇನು ಎಲ್ಲರೂ ಎದ್ದು ಹೋಗ್ಬಿಟ್ಟವ್ರೆ ವಾಚ್ ತಪ್ಪಿದ್ಯಾ ಇಲ್ವಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ
ಕಾಲ್ ಆಗಿಲ್ಲ ಇದೆಲ್ಲ ಬರುತ್ತಲ್ಲ ನನಗೆ ಇನ್ನು ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಹಾಂ
ಸರ್ ಅದು ಹೊಸದು ಎಷ್ಟು ಒನ್ ಡೇ ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟೋರು ಎಲ್ಲರದೇನು ಇದು ಹಳೇದಿತ್ತು